For the delivery of order, item number 1.
For reasons mentioned in the order, this prayer for bail is rejected at this stage.
For the delivery of order, item number 2.
Here also, for reasons mentioned in the orders, the prayer for bail is rejected.
Yes, please, your lordship, Mike. No, item number 23, Mike.
Yes.
My learned friend has appeared in this case for the ED.
I'm appearing for
For
the
the ED, they filed an application, my lord, yesterday here. We received also for modification and variation of the order and also an affidavit in this case. So we want some time to file a reply, my lord. 2 weeks time and your lordship can fix a date.
No, it is connected with,
Yes, these are connected cases.
which one?
23 and
So item number 30.
38 and
No,
23.
there is a problem. Because if you don't fix it at 14, there is an application which has been filed for modification variation of the order. Your
That
lordship
is
has
item
a-
number 38.
20.
23 and item number 38 is also by union, this interlocutory application.
Yes.
Yes,
So both are to be taken up together.
both are to be taken up. In fact, I was going to make a mention. Worship, I do agree that my friend on the other side has to respond to that.
My lord, we will respond it, but your lordship knows that 226 automatically it gets vacated, 14
That's
days.
2 weeks.
So 2 weeks, that's why I said, my lord, if it is not inconvenient, let it be fixed on 14th. That will be exactly on 2 weeks. 14th. 2 weeks automatically. 18 will be 2 weeks. 18, let it be 16, either 16 or 17.
17th is fine with me, Worship.
My daily is 17 hours. 16 by now. 16 by now. All application is serving for 16.
Oh, Worship,
Let it be 16.
Heard Mr.
Witnesses usually manually we have.
I'm okay with checking for
Yes. Heard
the
Mr.
applicants.
Heard me. No. Heard Mr. in item number 23. In 23, item number 23 was otherwise fixed for.
Otherwise fixed today.
There also you are mentioning.
There, Worship, I have filed my affidavit in opposition, and I have also filed an IA for vacating the interim order. Therefore, both the matters have to be taken up together, Worship.
Okay. You would be filing any reply?
Yes, we will file a reply.
Heard Mr. R.K.D. Chaudhary, Learned Central Government Standing Council, who submits that the respondent number,
All the responses.
respondents have filed their affidavit in opposition in this case. Also heard Mr. D. Das, Learned Senior Advocate, assisted by Mr. What's assisted by Mr.
Yes, last.
S. Das, who prays for some time for filing affidavit on reply to the affidavit on opposition filed by the respondent side. The prayer is allowed. Let this matter be fixed on
So on 16th, my
16th. In the meanwhile, the petitioner may file their affidavit in reply. Then in item number 38, heard Mr. R.K.D. Chaudhary, learned
Deputy SG Lordship.
Deputy, Deputy Solicitor General of India. In earlier also Deputy SGI. Also heard Mr. D. Das, learned senior advocate, appearing for the respondent who prays for some time for filing. In I also will be filing
Yes, we are filing. I also. We are filing objection.
objection to the interlocutory application. The prayer is allowed. Let this matter be fixed along with writ petition criminal number 3/2023 on 16th of August 2023.
Earlier interim order continues, my lord.
In
Orders, there are two orders earlier.
in item number 23, the earlier interim orders shall continue till next date.
Yes.
All right.
April orders.
With resolution, my lord, I think you mentioned item number 13. Here I have to, I am the respondent, I have to file an affidavit. But because of some documents, I could not file the affidavit. So a week time will be granted to me. They enable me to file the affidavit. And there's all the affidavit is ready.
Item number 13.
That is 1 3.
Heard Mr. Imti Imsong, learned additional advocate general, appearing for respondent number for whom you are appearing.
Respondent number 3, 4, 5, and 6.
3, 4, 5, and 6, who prays for some more time for filing affidavit in opposition.
1 week.
1 week time for filing affidavit in opposition. Also heard
Okay, come for respondent 1 and 2.
Mr.
Appeal Chisi.
Mr. Chisi, you write the name. Appear for respondent number 1 and 2. Also heard Ms.
And solo for the petitioner.
M. Solo for the petitioner, who does not oppose the prayer of the respondent. Hence, the prayer is allowed. Let this matter be listed after a week.
Worship, I have a similar for item number 32. Here I am for respondent number 4, 5, and 6. Your worship, here by the order dated 16 February 2023, I was directed to comply certain application. So it is already complied, but I am still waiting for instruction from the respondent. So 2 weeks time will be granted to me.
For, let him
Worship after the petitioner, this letter has been pending for a length of non filing of affidavit. So can we this be the last opportunity?
heard Mr. Imti Imsong, learned additional advocate general, who appears for respondent number 4, 5, and 6. Also heard Ms.
Your Lordship, I'm appearing on behalf of respondent number 1 to
Ms. Buchem, Conley Buchem, who appears for respondent number 1, 2,
1, 2, and 3.
1, 2, and 3. Mr. Imchen prays for 2 weeks' time for filing affidavit in opposition. On the other hand, Mr. Watson,
Mahaka.
Mr.
Worship, can we fix this letter on 10 August?
Mahaka, learned counsel for the petitioners, submits that as earlier also the respondents have taken time for filing affidavit in opposition. This may be the last time on which the prayer for adjournment may be allowed. No, prayer, leave for filing affidavit of opposition may be allowed. Considering the submissions made by learned counsel for the parties, the prayer is allowed. Let this matter be fixed after 2 weeks. Before 2 weeks. And in the meanwhile, the respondent number 4, 5, and 6 shall file their affidavit in opposition in this case.
Please, sir. I'd like to mention item number 29. Can you allow me 2 weeks time to file my affidavit in reply?
Mr. I. Im Chen.
Yes, Lord.
I. Im Chen, learned counsel for the petitioner who prays for 2 weeks time for filing affidavit in reply by the petitioner. Also heard Mr. Im T. Insam for learned additional advocate general for respondent number 1 and 2, who does not oppose the prayer of the petitioner. Hence, the prayer is allowed. Let this matter be listed after 2 weeks accordingly.
No problem.
Lordship, I need to mention item number 6 is a content matter. By the order dated 3rd July, I was 24 weeks time to submit the step taken by the respondent. But the lordship here is very sensitive and to take the step is very crucial. So I have an instruction to take some more time.
No, some more time, why?
Around
This
4
is
weeks
it.
time, because these many pertaining to two communities.
You are opposing? No. Heard Mr. Im T. Insam, learned additional advocate general, who prays for 4 weeks. How much?
4 weeks.
4 weeks time more to file
Step taken by the respondents.
affidavit in opposition.
Steps. Because I am taking steps.
Steps for complying with the
Yes, yes.
for taking step for complying with the order against which this contempt petition has been preferred. No, in respect of which this contempt petition has been preferred, considering the nature of the case involved. Learned Miss learned counsel for the contempt petitioner does not object to the said prayer. Hence, prayer is allowed. Let this matter be listed after 4 weeks. Yes.
Yeah, please, Lordship, I beg to mention item number 4 and 5. Lordship, our senior has some personal difficulties today, so I pray this matter may come up on the 17th of August.
Heard Miss
We can so
V.K. Solo.
Solo.
V.K. Solo, learned counsel for the petitioner, who prays for an adjournment on the ground that her senior Mr. Zimomi
Yes, Your Lordship.
Zimomi has some personal difficulties today. Learned counsel for the respondent does not object to the said prayer. Hence, the prayer is allowed. Let this matter be listed on
17th of August.
17th of August as prayed for.
My lord, I think to mention item number 15. This is also another contempt.
Item number 15.
May I please, Your Lordship? My Lord, let the matter remains because I want to make certain submissions. This is a contempt petition. During the pendency of this petition, the respondent is further violated the orders passed by this applicable court in the contempt petition. So it will remain in the list.
Let it be called.
Yes, let it be called, then I will make the submission then.
Next, Lordship. I mean, let me mention item number 35 and 36 on the hearing, Lordship. Lordship, here the leading counsel is trying to buy some bereavement. We'll bring them up for 2 weeks, Lordship.
Heard Mr. Foseco Forte, learned counsel for the appellant, who prays for an adjournment on the ground that the leading counsel, Mr. Time Chuba, is in bereavement.
Yes, Lordship.
You have,
2 weeks.
you have informed the,
Yes, Lordship.
it is also submitted by the learned counsel for the appellant that he has already informed the learned counsel for the respondent. Considering the submissions made by the learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks.
Yes, Lord. Thanks, Lordship. Lordship, please, Lordship, please be allowed to make a mention for withdrawal, Lordship. No. For withdrawal of the petition.
It is listed matter or unlisted?
No, unlisted.
Okay. At 2.
Lordship. Bless God.
This Lordship, I beg to mention item number 14 on behalf of Mr. N. Mozart. Your Lordship, pleadings are completed and we list this matter after 1 week.
Heard Mr. What's your name?
Benison B. Shure.
Benison B. Soe, who submits on behalf of Mr. N. Muzoe, learned counsel for the petitioner. Also heard Mr. N. Angami, learned senior government advocate. It is submitted at bar that the pleadings in this case are complete and this matter be listed for hearing. Admission hearing. The prayer is allowed. Let this matter be listed for admission hearing after a week.
Obliged. May I please, Lordship? My Lord, I beg to mention item number 7 on behalf of Livika, my Lord. Kindly list the matter after 2 weeks.
Heard Mr. E. Tiba Fom, who submits the ground is indisposition.
Yes. So he's not feeling well.
Who submits that the government council who is handling this matter, Ms. Livika, is indisposed. You have informed the council for the petitioner.
Yes.
It is also submitted that the learned council has already taken the consent of the learned council for the petitioner. Considering the submissions made, the prayer for adjournment is allowed. Let this matter be listed after 2 weeks.
And my Lord, I beg to mention item number 12. My Lord, here I am mentioning on behalf of AI, my Lord. Pleadings are complete, so let the matter be listed in the hearing, my Lord, after 1 week, my Lord.
After 1 week?
Yes.
Let it come up. Yes, Mr.
Lordship, in that case, after 3 weeks, Lordship.
Heard Mr. E. Tipafom, who submits on behalf of Ms. AIM Learned Government Council. Also heard Mr. S. Temjen, Learned Council for the petitioner. It is submitted at bar that the pleadings in this case are complete and the matter may be listed for admission hearing. Stop. Considering the submissions made by the parties, let this matter be listed for admission hearing after 3 weeks.
Please, Lordship, I beg to mention item number 26 and 27. Here, the leading counsellor, Mr. Siti January, has some difficulties today, so I pray that this matter be listed after 2 weeks.
Heard Ms. Asa Rutsa,
Yes,
K. Kuru, learned counsel for the petitioner, who prays for an adjournment on the ground of difficulty of Mr. leading counsel of this case, Mr. Siti Zamir. Also heard Mr. K.V. Angami, learned public prosecutor, Nagaland, who does not oppose the said prayer. Hence the prayer is allowed. Let this matter be listed
After 2 weeks.
after 2 weeks.
Meanwhile, it's an interim Lordship.
In the meanwhile, the interim order shall continue.
Lordship, I would like to mention item number 16. My
One
senior-
six. 1-6.
Yes, Lordship. The senior is engaged in lower course, so kindly allow listed on next week.
What is your name?
What is Jama? Yes, in the form.
This is item number 16.
Yes.
Heard Mr. So-and-so.
Small number 4.
Heard Mr. Wati Zamir, London Council for Respondent number 4, who prays for an adjournment on the ground of personal difficulties of his senior. Also heard Mr. Kivi Angami, London, appearing for state respondents. Also heard Ms. Only Puchim, appearing for the petitioners, who does not oppose the said prayer. Let this matter be listed after a week. Fixed date. Let this matter be fixed on which is the date.
On 8 Tuesday.
Let this matter be fixed on 8th of August in admission column.
Please, Your Lordship. Your Lordship, I beg to mention hearing item number 34. Your Lordship, if the matter be listed after 2 weeks.
Why?
Your Lordship, the leading counsel, he's out of station.
Heard Mr. Conley Buchem, London Counsel for the appellant, who prays for an adjournment on the ground that Mr. Santi Younger is out of station.
Lordship, I'm correspondent for 1 and 2.
Mr.
Kachi, Lordship, I'm appearing on behalf of my senior in Kumar.
Mr. Xavier,
Mr. Kachi, Lordship, appearing on behalf of my senior, Lordship.
Senior Mr.
In Kumar, Lordship.
So-and-so appearing on behalf of Mr. N. Long Kumar, London Counsel for respondent number 1 and 2, does not oppose the said prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
Next, Lordship, I think next item 20. Also, I'm yet to file a reply, definitely file a reply, Lordship. Can you have a bit of time, Lordship, to file my reply? Item 20.
Heard Mr. Foseko Forte, who prays for 2 weeks' time for filing affidavit in reply. In this case, Mr.
My Lord, I'm appearing on behalf of AIM.
Mr. E. Tiba Form, who is appearing on behalf of Ms. A.I. Milanen, Counsel for the state respondent, does not oppose the said prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
Not to the interim.
The interim order shall continue till next day.
Much of it.
May I please, Your Lordship. Your Lordship, I beg to mention item 22 on behalf of my senior, Mr. Yanawati, CGC. We have instruction to appeal for respondent number 3, so kindly give us a 4 weeks time.
Heard Miss. What's her name?
Asikile.
Asikile, who submitting on behalf of her senior, Mr. Yanderwati, London Central Government Standing Council, who submits that they will be appearing for respondents and prays for 4 weeks' time for filing affidavit in opposition. Also heard Ms. V. Sukre, who is Learned Additional Advocate General, who is appearing for state respondents. Also heard Ms.
K. Lilisu.
K. Lilisu appearing for the petitioners considering the submissions made by learned counsel for the respondents, the prayer is allowed. Let this matter be listed after 4 weeks. In the meanwhile, the respondents may file their affidavit in opposition.
Please, Your Lordship, I beg to mention item number 9. Kindly allow us 2 weeks time to file affidavit in reply.
Heard Ms. K.
Lily Su.
Lily Su, learned counsel for the writ petitioner, who prays for 2 weeks time for filing affidavit in reply. Also heard Mr. E.T.
My lord, I'm appearing for on behalf of Livika.
Mr. E.T. Bafam appearing for behalf of Ms. Livika, learned government counsel, who does not oppose the said prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
Much of this.
Please, Your Lordship, which I beg to mention item 8. Lordship, my senior, Mr. Gauhati, is indisposed, so I pray that this matter may be listed after 1 week.
Heard Ms. Desino Kiso, who is submitting on behalf of her senior, Mr. Yangarvati, and prays for an adjournment on the ground that her senior is indisposed. Also heard Mr. V. Zimomi, learned. You are appearing in this case? Learned government advocate who does not oppose the said prayer, hence the prayer is allowed. Let this matter be listed after a week.
Lordship, I beg to mention item 21.
21.
21. Here, I'm the respondent of the one for Lordship. Affidavit is under preparation, Lordship. 2 weeks time may be given, Lordship. 2 weeks time, Lordship.
Heard Mr. Who is for the petitioner?
Lordship, I'm for petitioner.
Heard Mr. V. Zimomi, learned government advocate, who is appearing for respondent number 1, who 124, who submits that the affidavit in opposition to be filed by respondents is under preparation and seeks 2 weeks time for filing the same. Also heard Mr.
For respondent 5 and 6. 5 and 6.
Appearing for respondent number 5. Also heard Mr. Elivil Zhao, London. Akru Chusi, learned counsel for the petitioner, who does not oppose the prayer does not oppose the said prayer. Hence the same is allowed. Let this matter be listed after 2 weeks.
Mr. Lordship, I beg to mention item number 11. I'm mentioning on behalf of Ms. Lucino for respondent number 6. Lordship, kindly get through this time to file the third one.
Heard Ms.
Wickets or no?
VK
Wickets or no?
VK Sono,
Yes or no?
submitting on behalf of Ms. Lucino, who is appearing for respondent number 6 and praying for 2 weeks time,
3 weeks time.
3 weeks time for filing affidavit in opposition. Also heard Mr. Enangami, who is appearing for state respondent, who submits that state has already filed its affidavit in opposition. Heard Mr. Mani Konyak, learned counsel for the petitioner, who does not oppose the said prayer. Hence, this prayer is allowed. Let this matter be listed after 3 weeks.
Please, Your Lordship, I beg to mention item number 33. Lordship, the service report on responsibility is still awaited. So if this matter can come up after 3 weeks, Your Lordship.
Respondent number?
Item number 33, Your Lordship.
Heard Ms. Viketi Sino, learned counsel for the petitioner, who submits that service report on respondent number 3.
Number 2, Your Worship.
Number 2 is still awaited. You will take fresh steps or we should await?
Lordship, this is the second time there is come out.
Okay,
Lordship, so
still awaited and submits that some more time be given for some more time may be awaited so that service report of respondent number 3 is received. Also heard Mr. K.V. Andami appearing for respondent number 1 and
I for 3.
Mr.
Arun.
R.N. Long, who is appearing for respondent number 3. Considering the submissions made by the learned counsel for the parties, let this matter be listed after
3 weeks.
3 weeks.
Lordship, it will be allowed to continue.
In the meanwhile, interim order shall continue.
Lordship.
Maybe Lordship.
Yes.
I beg to mention item number 50 on behalf of
30.
my lord. On behalf of Sir S.S.Day, leading counsel for the private respondents. Lordship, the leading counsel is out of station, so can I list after 3 weeks?
Heard Mr. Mane Konyak, who prays for an adjournment on the ground that Mr. S.S. Day, leading counsel for respondent
5 to
number 5 to 16.
May it please your lordship. I'm appearing for the respondent number 5. And the respondent number 5 has filed an IA. And a reply has been given regarding the IA. So the IA may be heard and disposed after fixing a date, your lordship. There is no objection from the petition.
Today for IA,
Lord,
IA is also listed.
yes, ma'am. I have no instruction on that.
IA 43 of 23.
IA 43 is not listed today.
My apologies, I thought it was item number 30.
Yes, IA 43. Yes.
Yes. And, the previous is the same. I'm appearing for the respondent 5 only. The pleadings with regard to the IA has been completed.
Yes.
Lordship, all the IA has been taken up to beautiful hearing.
Or let it be called, then we will pass orders. Or are you conceding to his prayer for adjournment?
Beg your pardon, Lord.
He has sought for an adjournment today.
Yes.
Are you conceding?
Lordship,
He is submitting that all the ayahs may be heard together.
because in respect of IA 43, the petitioner and respondent number 5, only respondent number 5 and the petitions are the parties. The other respondents are not parties.
Not parties.
Yes.
But then we will hear it. You are not appearing for respondent number 5.
6 to 50%.
As regards the
If there is no objection, it may be fixed on 10th Thursday.
okay. Heard Mr. Mane,
Lordship, if the matter will be fixed on 14th instead.
you finalize the date.
Yeah. Lordship, we agree on 14th.
Heard Mr. Mani Konyak, Lanet, who is submitting on behalf of Mr. S.S. Day, prays for an adjournment. S.S. Day, who is appearing for respondent number 6 to 6 to 15. 6 to 15, press for an adjournment on the ground that Mr. S.S. Day is out of station. Also heard Miss
And so,
Hensolo for the petitioner, as well as Mr. Jakatu GC for respondent number 5, who conceding to the prayer made by Mr. Mani Konyak, prays for fixing this matter on 16th, 14th of August. The prayer is allowed. Let this matter be fixed on 14th of August.
Your Lordship, there's an interim.
The interim order shall continue till next day.
Likewise.
May I please, Your Lordship? I beg to mention item number 10. Kindly grant us 3 weeks time to file a reply. 10.
Heard Miss Loshino
And so,
Hensolo, learned counsel for the petitioner, who prays for 3 weeks time for filing affidavit in reply. Also heard Mr. Mane Konyak, who does learned counsel for the respondent number 3, who does not oppose the said prayer. Accordingly, the prayer is allowed. Let this matter be listed after 3 weeks.
For motion, item number 1.
Mr. Lordship. Lordship, the release application, your petitioner is seeking for release of the alleged person on bail on medical ground, Lordship. Lordship, the alleged person was arrested on the 5th of July 2023 on alleged recovery of several months of life ammunition and rupees 500 currency note amounting to rupees 26,000. Now, Lordship, on the 12th of July 2023, the bail application of the alleged person was heard, and accordingly, the bail application was granted on 12th July 2023. Thereafter, Lordship,
Granted by the magistrate's court.
magistrate first class, judicial magistrate first class. However, Lordship, the alleged person was not able to furnish a surety, so he was sent back to judicial remand for some time. So, in the meantime, the prosecution filed an application under Section 437 clause 5 for cancellation of the bail order, bail granted to the alleged person. So, accordingly,
Bail was cancelled. Bail was cancelled. So, perusal of the case diary may be necessary, I think. Mr. Angami?
Lordship, I think
Yes. You complete your submission. No, what we propose, we will call for the case diary.
Oh, okay, Lordship. Okay. Notice may be issued, Lordship.
Heard Mr. What's your name?
Chinmay Konyak.
Mr. Chingmai Konyak, learned counsel for the petitioner, learned counsel for the applicant. Also heard Mr. K.V. Angami, learned public prosecutor. Considering the nature of allegations leveled against the present applicant, as well in the FIR, as well as considering the fact that earlier bail which was granted to the present applicant was cancelled on application of the prosecution side. When it was cancelled?
On 18th of July.
On 18th of July 2023 by JMFC. Where? JMFC fake. perusal of the case diary is felt necessary for consideration of the present bail application, hence call for the case diary. Learned public prosecutor shall produce the case diary within a date should be given.
18.
Let this matter be fixed on 18th August for case diary, on which day the learned public prosecutor shall ensure the production of the case diary.
For a motion, item number 2.
Lordship, this IAS filed to provide necessary corrections in the writ petition by amending the writ petition. Lordship,
Yes.
in para 2, last line of the writ petition, there is a typographical error where instead of the number 24, 20 is written. So I've met this application for correcting the same and filing an amended writ petition.
You have anything to say?
No,
Mr. Haringlong, learned counsel for the applicant. Also heard Mr. E. Tibafon, learned counsel for the opposite parties. This instant interlocutory application has been filed by the writ petitioner of WPC number 133/23, praying for amendment of writ petition to correct the typographical mistake in where
Page 4, paragraph 2.
in the last line of paragraph 2 of the writ petition. By correcting the typographical error in the number 20 with number 24. Only this much.
Only this much.
24. Learned counsel for the respondent. The opposite party does not oppose the said prayer, hence the prayer is allowed. Let the amendment as sought for be done by the petitioner. And amended, how you will do it?
I will file an amended petition and if the matter can be listed on Monday.
What is the last line? By the petitioner. And an amended petition be filed in the WPC 133/2023 within how many days?
File within the course of the day.
Today, within the course of the day. With above observation, this instant interlocutory bail application, instant interlocutory application is ever disposed of. In writ petition number in WPC 133, in view of the order passed in I number 80/2023, let this writ petition be fixed again
on Monday
in motion column on Monday. Monday, that is, let it be Tuesday.
7.
Let it be on 8th. On 8th of August 2000.
Much.
item number 3.
Yes,
Lordship, I have two IA, and then the first IA is for the amendment of the repetition.
which
On
is
the-
which is the
The
first one?
first IA is for the amendment,
I number 85.
Lordship.
No, amendment is the second I. 86, I think.
Lordship, I have requested the registry to list to give the number for the first number for the amendment.
But they have given it after the your stay application. So 86 will be taken up first.
That is for your Lordship.
No.
For my,
Amendment.
I would like to read the first amendment.
Amendment. That is I number 85.
Lordship.
86.
This is.
I number 86. Yes.
Lordship. Now, Lordship, after the institution of my repetition, I have challenged the administrative approval. And then the court has heard the matter, and then accordingly, order was passed on 17th, 7th, 23. Thereafter, on 19th, the state respondent has issued the appointment order. So, in lieu of that certain subsequent development, I would like to amend my petition by inserting some additional paragraph in my petition.
Which amendments you have?
Lordship, if you kindly turn to my paragraph 3 of my amendment IA, page 5. So, Lordship, after paragraph 8 of the petition, I would like to insert paragraph 7A by stating the next year appointment.
You have any objection to the amendment?
No, amendment of the Lordship.
In I number 86/2023, heard Mr. S. Timjen, learned counsel for the applicant, also heard Mr. N. Angami, learned senior government counsel for the opposite parties. This instant interlocutory application has been filed in connection with writ petition number in connection with writ petition number 123/2023, seeking amendment of the writ petition by incorporating some additional paragraphs in the writ petition as stated in paragraph number 3 of the interlocutory application. I need not mention the reasons as he is not opposing. They had paragraph 3 of the interlocutory application. As learned senior government advocate Mr. N. Angami, who is appearing for the respondents, has not opposed the prayer for amendment. The prayer for amendment of the writ petition as desired is allowed, as prayed for is allowed. The petitioner shall file an amended writ petition within
By 8 of this month, that is Tuesday, Lordship.
on or before 8th of
Lordship.
this month. With above observation, this interlocutory application is hereby disposed of.
Lordship.
Yes.
The second again, Lordship. Now, Lordship, my second IA is for interim lordship. Lordship, the administrative approval which I challenged my repetition, it was made against the office memorandum. Why? Because the private respondent 5, who was the daughter of the retired employee. And Lordship, if Lordship may kindly turn to my next
No, whether it is to be disposed of or it may be taken up after you file your amended petition.
Lordship. Because the point in bringing before is that
But that
in
amended petition is not before the court, amended rate petition. That otherwise also in the rate petition itself, an order was passed that it would be subject, any appointment would be subject to the outcome of the writ petition.
Lordship.
So,
But that is only my prayer, Lordship. Despite of that order, we have served, we have taken the steps. Yet on the next day, that is 18,
there was no bar. There was no bar.
Lordship. That's why I'm coming for stay, Lordship. At this
So let it be taken up after you file your amended petition.
Lordship, my humble praise that since the Honorable Court has already allowed my amendment since with that effect, on that effect, if my prayer is considered, because see here, illegal appointment is cannot be perpetuated in the department. So many
No,
things.
actually legality of that appointment is under consideration in the writ petition.
Yes, Lordship.
Yes. And the court on last occasion made very
clear
that any appointment would be subject to the outcome. In that way, whether this IA is necessary.
Lordship, on the last occasion I have prayed for that, but the court has given on that.
Then you file the amended writ petition.
Lordship.
Thereafter, it will be taken up.
Lordship.
Let him file the amended writ petition.
Lordship.
Because
knowing the respondent against the office memorandum, they are doing the illegalities. That is why Lordship, petitioner is suffering irreparable injury.
Will you be filing any written objection or only objecting this IA?
Lordship, if the petition is amended, that means it has to be filed afresh again, Your Lordship. However, having said that, Your Lordship, if the petition is pressing on this IA, I just have to make one submission then in that case, Your Lordship, because Lordship, this is the same prayer the petitioner has made in the writ petition. He himself in this IA has mentioned that the court has heard the parties.
So therefore, let it come up after
amending
heard Mr. in IA number 1, in IA number 85 of 23, heard Mr. S. Temjen, learned counsel for the petitioner, learned counsel for the applicant who has filed this instant interlocutory application. Praying for suspension of the impugned administrative approval number so and so dated, improved, praying for suspension of the administrative approval which has been impugned in writ petition number 123/23. Stop. Also have Mr. A. Nangami appearing for the respondent. In the meanwhile, another interlocutory application filed by the present petitioner seeking some amendment in the writ petition file, writ petition number 123/23 filed by the petitioner has been allowed, and the petitioner has been directed to file the amended writ petition on or before 8th of August 2023. In view of the same, let this interlocutory application be placed along with the writ petition, with the amended writ petition number 123/23, on which date you want this to be fixed?
Lordship, the main petition was fixed for after 4 weeks.
So you want it to be fixed on 4 weeks?
Lordship,
Because main petition is again listed today also.
Yes. Yes.
We can fix it earlier also,
Yes.
so that interlocutory application may be heard. Because it has to be placed along with the writ petition.
Lordship.
Last line. Writ petition number so and so, on which date you want? After a week.
Lordship after.
Or you want a fixed date?
After a week.
After a week. After a week, along with WPC number, no, that I have stated, along with after a week.
All right.
For motion from the supplementary policies, item number 39.
Make this motion. In this petition, I'm seeking 3 prayers. One is to consolidate the 2 FIRs which have been filed, one in Dimapur district and the other in Newland district. The second prayer is to consolidate any future FIRs which may be filed against the petitioners. This has been necessitated because of the threats which have been conveyed by the associates of the complainants. And the third prayer is to a direction to the official respondents, especially the respondent number 2, who is the superintendent of the Sub-Jail Dimapur, to forbid the associates of the respondent number 5 and 6 to visit the petitioners. The facts leading to the filing of the FIR. The Lordship may have page 28 of the petition. This is the agreement, an agreement which was executed on 8th March 2021. This was
Yes.
by the petitioner.
Where is the FIR, main FIR?
Yes, based on this.
Acha, what is this? What is this
Yes, it
agreement?
was based on this agreement that the FIR was filed. Agreement was for investment in real estate properties, and it was
Agreement is
respondent number 5
Okay.
and the company in which the petitioner is one of the directors, where the respondent apparently reportedly invested 14 crores, and a promise was made that 20 crores would be returned to the petitioners after 2 years. A post-date check was issued to the petitioner, and when the petitioner he went to encash the post-dated check, it was returned as the account being blocked, based on which the FIR, which is at page 26, has been filed. Page 26.
No, post-dated check was issued by the petitioner.
No, by the co-accused.
By the co-accused.
Who is on anticipated bail at the moment.
Okay.
The post-dated check, Your Lordship, can.
Now, where is the FIR?
The FIR is page 26. This is the first FIR.
This is a long FIR. On page 26.
Yes, page 26, where the respondent number 5, the complainant alleged that based on the agreement, he was supposed to get 20 crores in return, but the company has not returned it, based on which the FIR was filed, alleging the case of cheating and criminal breach of trust. In the same manner, the Lordship will also see that respondent number 6 also filed his FIR at page 32. Page 32 is the FIR of the respondent number 6. And in this also, the agreement is the content is more or less the same, except for clerical and mathematical changes made to the agreement. The agreement was
Agreement is a different agreement.
It's The amount is different. That's it.
That means it is a different agreement.
It's a different agreement.
So
But
nature, it is similar, but not same.
One
The
suggestion
first
is-
FIR and second FIR pertains to same incident or two different.
It is part of the same transaction. There is my contention. It is part of the same transaction. If your lordship can see the agreement and the manner in which it was executed, it is part of the same transaction.
No.
This was also filed on the same day.
In the first agreement,
Yes.
the contention was you took 14 crores rupees from the complainant with a promise to return him
Not me, the company.
the company.
Yes. And the company has not been arraigned as an accused.
Okay. And in the second FIR,
Yes.
another person,
Different person.
different
same
person
company.
against the same company
Yes.
lodges a complaint that from that person also the company took so and so money.
So, some amount of money. With a promise that they will return 15 crore. 11 crore was taken, 15 crore will be returned. I'm denying those. I'm denying the fact that the money was taken, but so based on that, the FIR, second FIR was filed.
Okay, notice have to be issued then.
Yes, but while the petitioner, he has been arrested and the police
Petitioner is now in custody.
Yes, he's in judicial custody. While the petitioner was in police custody, as well as judicial custody, the associates of the respondent number 5 and 6, the complainants, which includes the co-accused, as well as an advocate, they have been paying unwarranted visits to the petitioner, threatening him that if he does not do a monetary settlement, they will
But you are in jail. You are in judicial custody.
Yes, but they are visiting.
Without.
Yes, even I made a statement that on 30th July, they visited again, threatening him that they will file future fake FIRs.
No, but you, while in judicial custody,
yes,
whether anybody can compel you to meet a visitor.
No, nobody.
Then you don't meet them.
No, but they through the, because of their reach of contact, they have been visiting me. And I've been brought up to meet that forcefully.
You are compelled to meet them.
Yes, that's why I'm seeking an interim prayer directing to direct the respondent and not to allow the associates of the respondent to visit the petitioner
without your consent,
except for the legal counsel or his relatives as permissible by law. One of the.
Yes, Mr. Angami. And heard Mr. L. Iralu, learned counsel for the petitioner. Also heard Mr. K.V. Angami, learned public prosecutor, Nagaland. This criminal petition has been filed under Section 482 of the Code of Criminal Procedure, 1973, by the present petitioner, praying for clubbing of FIR number 29/23 under Suburban Police Station, case number 29/23 under section 409/420/34 of the Indian Penal Code, with another FIR bearing number 20/23 under Newland Police Station under section 420, 406, 471 of the Indian Penal Code, and also with a prayer for clubbing all future FIRs that may be filed against the present petitioner in connection with the false cheating cases in the state of Nagaland. Stop. It is also prayed for. No, stop. Where is the statement that the associates are meeting?
What may come to paragraph 80
of page 17, paragraph 18. Page 17, paragraph 18.
Learned counsel for the petitioner has submitted that the petitioner has already been detained in judicial custody in connection with the Suburban Police Station case number 29/23. On which date you were arrested? On which date you were arrested? Since when you are in custody?
13 June.
On
13 June 2023.
since 13 June 2023. And it is submitted that while the petitioner is in judicial custody in which jail?
Sub-jail, Dimapur.
In sub-jail Dimapur. Some frequent unwarranted visits have been made by the associates of respondent number 5 and 6. Including an advocate based in Dimapur and the co-accused Mr. Varun Kumar Gandhi without the consent of the present petitioner. And it is alleged that they have been threatening the present petitioner to do the monetary settlement in the case or to face dire consequences. Let notices be issued to the respondent. How many respondents are there?
4 official respondents and 2.
Let notices be issued to the respondents returnable within 4 weeks. Stop. As Mr. K.V. Andami has accepted notice on behalf of respondent number 1, 2, 3 and 4. 1, 2 and 3 and 4. No separate notice need to be issued to the respondent number 1, 2, 3 and 4. However, requisite numbers of the petitions, requisite numbers of the copies of the petition shall be furnished to the learned public prosecutor by the petitioner so as to enable the respondents to seek necessary instructions in this regard. As regards respondent number 5 and 6, the petitioner shall take steps for issuance of notice through registered post with heading returnable within 4 weeks, within a period of 3 days from the date of this order. In the meanwhile, considering the nature of allegations, considering the allegations made, paragraph number 18 of the petition, as well as considering the submissions made by learned counsel for the petitioner, the superintendent of sub-jail Dimapur is directed, in interim, to not to allow. How we will know that who are the associates of 5 and 6?
If anybody comes to visit the petitioner from there, he can accept him because all these things are
Not
there.
to allow any visitor to meet the present petitioner while he is in custody without his consent.
Except,
No,
it's
they
legal
will
counsel.
take, superintendent will take
Yes.
your consent, whosoever want to meet you.
Yes.
Without his consent, stop. Let this petition be listed, let this case be listed again after a period of 4 weeks.
For item number 14.
Yes, Lordship. Lordship, the petition is, of course, on the court. Ready for watching the proceedings, the FIR and the charge sheet. The petitioner has been running a business and the complainant by FIR dated 16/5/2026, which is page 11 and actual 1, complained that he has not received the consignment. that is reported.
Page 11?
Page 11, this is the FIR.
Yes. What was the allegation?
The allegation is that the complainant has ordered one laptop, but he has not received the laptop. So he has made a complaint before he waits on the station. And accordingly, the accused was arrested. After the arrest, the Lordship, the father of the petitioner and the complainant have come into a compromise, and the father of the present petitioner has paid the money which has been deposited by the complainant to the account of the.
You are in custody now, or you are on bail? Are you in custody?
Lordship, I'm on bail.
You are on bail, okay.
So they've come into a compromise, and the compromise it is at page 14, actual 2. The complainant is Mr. So-and-so, and Luma is the complainant, and Lathar Olukdar is the father of the.
Okay, let the notices be issued.
So in the meantime, the proceedings can be.
No, even it is not required to be state. Only investigation is going on.
Lordship, charge sheet has been filed, Lordship.
Charge sheet has been filed.
Okay, Lordship. That's well, Lordship.
Whether the offences are compoundable? No.
Lordship, there are four sections, Lordship. 2 sections are compoundable, 2 sections are not compoundable. In fact, Lordship, the petitions that approach the court below.
You have appeared before the court.
Lordship.
At what stage the case is pending?
Now, Lordship, it's a CC, Lordship.
For charges,
yes.
Consideration of charges.
Charges been filed, Lordship. And Lordship, the petitioner has approached the court below for questioning the proceedings since they have been a compromise between the parties. But Lordship, since there are 2 sections which are not compoundable, the court below has rejected the application. The Lordship, the petition is able for someone to court for questioning the proceedings as well as the FIR and the charge sheet, Lordship.
Just make allegation first.
Heard Mr. Foseco Forte, learned counsel for the petitioner. Also heard Mr. K.V. Angami, learned public prosecutor. This instant petition under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Shri Deepjyoti Talukdar for quashing of the proceeding of GR case number 429/2016 pending in the court of Judicial Magistrate First Class Dimapur, as well as the FIR dated 16/5/2023. The facts the case of the petitioner is that on 16/5/2023, one Vimathon Newmai, Newmai, Newmai lodged an FIR before the officer in charge of West Police Station, inter alia, alleging, alleging that you are named in the FIR.
Not yet.
Have you been named in the FIR? Yes. That the present petitioner had cheated
Yes.
the first informant after taking money amounting to rupees 19,012 for sending a laptop in lieu of the said consideration amount. However, the said laptop was not delivered to the first informant. On receipt of the said FIR, the West Dimapur West PS case number 95/16 was registered, and later on, charge sheet was filed against the present petitioner under section
Lordship, here, there's no section. Page 16 says the final form report under section 123 of the Charter Scheme. Page 16.
No. What are the penal offences under
Penals of 120B,
under section 120B
420,
/420
406,
/406
471.
and 471 of the Indian Penal Code? The petitioner is presently enlarged on bail. Stop. It is submitted by learned counsel for the petitioner that in the meanwhile, the petitioner has already reached a compromise with the first informant and respondent number 2 of this instant case, first informant of the criminal case, who is also the respondent number 2 in the instant case. Where is the compromise? From where?
Compromise is at page 14, section 2.
And in support of the said contention, a copy of compromise deed between the first informant as well as is the father. Compromise deed is between the first informant and the father. Between whom?
The informant, there's a complainant, and the father of the petitioner.
Between the informant as well as father of the petitioner. This last line is last line. Please read the last line. Has been furnished along with the instant petition as Annexure 2. Let the notices be issued to the respondent side as Mr. K.V. Angami, public prosecutor, receives notice for the respondent number 1. No separate notice, no formal notice is required to be sent to respondent number 1. However, requisite number of copies of petition may be furnished to the learned public prosecutor by the petitioner within the course of the day or within
2 days.
Within 2 days. As regards respondent number 2, the petitioner shall take steps for issuance of notice through registered post with ID returnable within 4 weeks. Stop. These steps shall be taken within a period of 3 days from today. In the meanwhile, considering the fact that a compromise has already been reached between the first informant and the present petitioner, as well as considering the submissions made by learned counsel for the petitioner, further proceeding of GR case number 429/2016 pending in the court of learned judicial magistrate first class Dimapur is hereby kept in abeyance till further order.
Thank you, Blessings.
Let this case be listed again after 4 weeks.
Much obliged.
For motion, item number 41.
It is a motion. This petition, petitioner before lawsuit is challenging the proceeding initiated against him, my lord.
Use mic.
Initiated against him, my lord, by Dimapur PS case number 43 of 2023. Which will find the FIR at page 13.
Yes.
Well,
Yes, it is a long affair. You can tell me the gist.
the gist of the affair is that the informant ordered some articles from the petitioner, my lord. The petitioner has a business establishment at Gauhati. The informant went to Gauhati to purchase some articles. He paid some amount. As per the informant, the articles were not delivered to him. That is his allegation.
Okay.
On the basis of the affair, a notice was sent by the police, which will find a notice at page 15. Page 15. Under section 41A, CRPC.
Yes.
Asking him to appear along with the documents. Then the petitioner before lawsuit submitted his reply. The reply was will find at page 70.
Yes.
And may read the reply.
Yes.
Reply.
Yes.
Sir, Mr. First, I understand would like to inform you that I have received your notice communicated under section 41A CRPC, issued under Suburban Police Station GT number so dated 5/6/23. And on perusal of the same, I was shocked and surprised that on empty Imsong has lodged one complaint information against me, but originally there is no dispute in between us, and same was filed only with the sole intention to harass me and of me out a handsome amount. The facts of the case is that since from 21 till 2022, he started to purchase various trucks of cement and TNT bars amounting rupees 42,95,000. And as per his specific instruction, I delivered the said materials to his destination place after following all process of law. However, the sum of 16,845 remains outstanding on my hands, which I have agreed to refund. But the said persons with sole intention of out a handsome amount started to demand an exorbitant amount of rupees 5 lakhs from and further threatened me with dire consequences if I would not make the said demanded amount. He would file false complaints against me and forcefully call me at Nagaland, whereby he could kidnap me and demand ransom from my family. This is the analysis of the reply filed by the petitioner. Also, we find the bank statement. The allegation of the informant is that he paid an amount of 13 lakhs 62,000. But in fact, my lord, he paid 42 lakhs, not 13 lakhs. 42 lakhs.
No, in FIR, what was the allegation? 13 lakh?
In the FIR, he says, my lord, third paragraph proceed find the amount. 13 lakhs 62,000. Third paragraph. Fourth line. 13 lakhs 62,000.
Yes.
But the actual amount was, my lord, 42 lakhs 75,000.
Okay.
Business transaction, my lord. So you find the bank statement of the petitioner, my lord, wherein the money was deposited by the informant. Page 18 onwards, my lord. So you find the first transaction at page 19. First amount was deposited in the account of the petitioner. Page third, 21 October 2022, he deposited 5 lakhs. 21 October.
Yes.
Next transaction was we find at page 21. Page 21. November, 6 November, again he deposited 5 lakhs. 6 November. Next month was we find page 22. 9 November, 1 lakh 25,000. Again, down below, 10 November, 2 lakhs. 21 November, page 24, my lord. Page 24. 1 lakh 38,000. 21 November, first column, my lord. Next to page 25, 26 November, 3 lakh 62,000. Page 27, my lord, 2nd December, 5 lakhs. Page 27. Page 23rd December, 2 lakhs. Next, page 29, my lord. 5th December, the deposit was, my lord. First amount was 3 lakhs. Next, my lord, 2 lakhs 50,000. Page 29.
Okay, ultimately, how much you
Received by money. The amount was not deposited in a single day.
on different
On
occasions?
different occasions, my lord, after receiving the articles, my lord, he kept on depositing the amount.
So total 42 lakhs 95,000
42 lakhs 35,000
was paid by the informant.
by the informant. And my lord, also you find the, my lord, ledger at page 38. Which amount was deposited by the informant and the articles delivered by the petitioner.
Okay.
These are the articles delivered by the petitioner. But I have also got the tax invoice and my EOB on page 39 onwards. Everything is in black and white.
This is to the tune of 42 lakhs.
Yes, ma'am. Total amount, madam, I have delivered 42,078,155. The articles, madam, amounting 42,78,155. And the outstanding is 60,845.
Yes, now what happened after FIR?
After the FIR, madam, the first of all, madam, this
The notice,
FIR should not have been
you
registered in Dimapur.
You have responded to the notice issued.
Yes, madam, I have responded.
Thereafter, what happened?
Thereafter, madam, police visited my place, around my house in my absence to madam, arrest me.
In Gauhati?
In Gauhati. The incident took place in Gauhati. Business transaction was done in Gauhati, madam. How could the Adnapur police register a case against me? They should have registered, received the FIR and registered a 0 PS case and forwarded to the district police station, madam, for investigation. This is purely a civil transaction, madam. Civil transaction, madam, there is no.
Okay, let us see. Yes, Mr. Zimami.
As regards this incident, my lord, after
Now, what is the stage of the proceeding? It is pending in the
investigation, pending investigation.
investigation stage.
Yes, I am being detained. That is why I also lost the FIR before the district police station. Second FIR was lost. That has been clapped with the original FIR. That has been numbered. And this district police station is also investigating into the matter.
FIR against the informant.
Against the informant.
Lordship, here the complainant is the resident of Dimapur. And the transaction that was took place in Dimapur, transaction that was made in Dimapur. So it has been registered in suburban police station where jurisdiction lies. However, Lordship, at this stage, since the petitioner, they have met respondent number 1 complainant and respondent number 3 public prosecutor Assam Lordship. So there has to be heard, and moreover, I am for the respondent number 2 Lordship. So Lordship, at this stage, notice may be issued, Lordship.
Now, why have you made public prosecutor as a party?
Well,
as respondent instead of making state as respondent?
Yes. State is a party, represented by the public prosecutor.
No. You have made public prosecutor as a party.
Lordship. Since I
My
have
lord, sorry, my lord, state should be a party. I will correct it, my lord, by hand.
No correction by hand. There
let
is
them file an amendment in that way.
let the notices be issued to the respondents. I'm issuing notice.
In the meantime, further investigation will be state, my lord, because
No,
my lord,
Lordship.
I am being detained. I am being detained. If I come to Dimapur,
No.
my lord, I will be
Lordship, no Lordship.
That is the only. My lord, I have detained to the police also, my lord, in pursuant to the.
No, let the investigation proceed.
Lordship,
You
Lordship.
cooperate
There should be an
with in the
independent
investigation.
I will cooperate if take, my lord, my statement is recorded in this police station. I cannot come to Dimapur, my lord. That is the only difficulty, my lord. Because the informant, my lord, is from Dimapur. Then, my lord, I have to threaten to my life, say to my life. Here at Dimapur, my lord.
All people in Dimapur are facing threat.
No, I'm not saying that, my lord.
Then-
But the incident was noticed. The transaction took place in Gauhati.
No, you have also filed an anticipatory bail petition.
Madam, if the proceeding is state, madam, I will do the bail application, madam.
No, you pursue the bail application. Let the proceeding remains. Let the investigation go on. At this stage,
Only prayer will be, madam, my statement will be recorded at district police station, madam. I will appear before the district police station at any moment, whenever I am called, my lord, I will appear.
no, your statement may be recorded by video conferencing also.
That can be done, madam. That
No,
can be done.
Lordship,
That can be done.
through video conference, it's a little bit difficult, Lordship. On earlier occasion, in one of the case, Lordship, the police, the investigating agency, they find it very difficult to go through video conference, Lordship. Since documents, some pertaining documents has to be placed before the police station. Lordship. So in that matter, Lordship says, some to Dimapur, it's just a few kilometer, Lordship. They can come and Lordship appear before the police station, Lordship.
I okay not to go. Okay, uh, that order will be passed in AB while considering how you have to cooperate. If even after hearing your anticipatory bail application, here we are issuing notices only.
Lordship.
Bail application, madam.
Let us hear first. We will be taking the bail application next
Yes, madam.
as next item.
This, along with this, also take up the bail application.
Yes. In item number 41, heard Mr. I.H. Soikia, learned counsel for the. This is item number 41.
41.
I.H. Soikia, learned counsel for the petitioner. Also heard Mr. V. Zimami, learned public prosecutor for Nagaland, appearing for respondent number 2. This instant criminal petition under section 482 of the Code of Criminal Procedure, 1973, has been preferred by the petitioner Ajay Bahadur Singh, praying for quashing of the FIR, where is praying for quashing of the FIR which was registered in FIR which was lodged by the petitioner number one, no, respondent number one of this case, and was registered as Dimapur PS case number 43 slash
Suburban Police Station, Dimapur.
Suburban Police Station case number. You have mentioned wrong case number in the 43 slash 23. 43 slash 23 under section 420 slash 406 of the Indian Penal Code. Let the notices be issued to the respondents. As Mr. V. Zumomi has received the notice for respondent number 2, no formal notice be sent to respondent number 2. However, requisite copies, numbers of copies of the petition be furnished to the learned public prosecutor Nagaland. As regards the other respondents, the petitioner shall take steps for issuance of notice to the.
Well, this will not be necessary party participation.
Then you have to pray. Later on, if amendment, deletion, anything is
Yes,
required.
I will. Because when initially this petition was supposed to be filed in Gauhati, the permission was given, and therefore I have to file this application here.
As regards other respondents, the petitioner shall take steps for issuance of notices through registered post with AD, returnable within 4 weeks. Stop. The steps for issuance of notices on respondent shall be taken by the petitioner within 3 days from today. Let this matter be listed after 4 weeks accordingly.
Notice on indirect payment issue.
No, interim prayer is included in the notice itself. You have not filed any IA. In the main.
Main prayer I have also written the interim prayer.
So that would cover it.
Again, 3 along with this.
Call item number 43.
Motion item number 43.
You appear before the, in interim, you appear before the IO with the protection. I am giving you protection. Once you appear, later on, if your appearance is required by the IO, later appearance may be through video conferencing. In the
This two police station were already for
no, that convenience will also be given to you later on. But first instance, you have to appear before the IO. You will be given protection from arrest in interim. And Mr. I.H. Soikia, learned counsel for the petitioner, also heard Mr. V. Zimomi, learned counsel for the learned public prosecutor, Nagaland. This instant application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the present petitioner, namely Ajay Bahadur Singh, who is apprehending his arrest in connection with Suburban Police Station case, Suburban Police Station, Dimapur. No, what is Dimapur Suburban Police Station case number 43/23 under section 404 420/406 of the Indian Penal Code. The accusation, ACCUTION, accusation in this case is that, where is the affair?
FIR also it will be fine. Page 11.
Accusation in this case is that on date of FIR is, on which date FIR was filed?
5/6/23 plus.
On 5th of June 2023.
It was lost, my lord.
One Inti Tenesu in song lodged an FIR before the officer in charge of Suburban Police Station, Dimapur, inter alia, alleging that
The type copy is 12A, 12. I give that copy also.
that the first informant had contacted the present petitioner to purchase TMT rods, cements, and other miscellaneous iron material from him, which are to be, where it is to be sent to Dimapur.
It was supposed to be sent.
Which are to be sent to Dimapur, and against the said contract, the informant has paid an amount of rupees 13,62,000. However, it is alleged that though the present petitioner had agreed to send the said articles, said materials to the informant, however, same has not been received, and the present petitioner has committed criminal breach of trust and cheated the informant. And cheated the informant. Stop. On receipt of the said FIR, Dimapur Suburban PS case number. What is the PS case? Suburban PS case number 43/2023 was registered. Stop. Now, what is your submission? You have supplied the materials.
I have supplied that. Yes, madam. Only some 16,000 much smaller is to be paid by me.
On the other hand, no, it is submitted by learned counsel for the petitioner that there was a business relationship between the present petitioner and the first informant, and in fact, the
42 lakhs, 95,000.
the first informant had paid 42 lakhs 90. What was the amount?
95,000. 42 lakhs, 95,000.
42
lakhs.
Paid an amount to the tune of 42 lakhs 92,000 to the present petitioner on different occasions, and it is submitted that the materials against the said payment have already been delivered to the first informant, and only a sum of rupees 16. What is outstanding?
Outstanding is 16,345.
only sum of rupees 16,800, 800 and page number
Page 17, Mr. 4.
16,845 remains outstanding against the present petitioner, which according to the present petitioner, which according to learned counsel for the present petitioner is ready to pay back. It is also submitted by learned counsel for the petitioner that after registration of the FIR against by the first informant, the petitioner received a notice under section 41A of the CRPC from
It was sent on 6/6/23, my lord. Page 13.
from the investigating officer of Dimapur Suburban PS case number
Case was registered later on.
later from who has sent the notice. The
One.
From the investigating officer of the case. Stop. It is further submitted that in pursuant to the notice, the present petitioner had sent a written reply on 14/6/2023 to the investigating officer, making his stand clear therein, and also stating therein that if there is a dispute between the parties, it is in the nature of civil dispute. Stop. It is further stated in the bail application that in spite of furnishing reply by the present petitioner to the investigating officer, when the police visited your house,
My lord, after issuing the third notice, my lord.
where is the statement?
Second notice is Washington page 61.
No, where is the statement that because of which you are apprehending your arrest? When police visited? You have mentioned that police have visited you, Gauhati.
Yes, my lord.
Where is that statement? Or why are you apprehending your arrest? It is submitted by the learned counsel for the petitioner that after issuing the first notice, the investigating officer issued other two notices and thereafter have tried No, this statement, where is the basis that police will arrest you? Basis of your apprehension. Because 41A notice is issued, it means that he will not be arrested. And therefore, in which paragraph? Para 8. Police came to arrest him.
My paragraph 8, my lord.
Thereafter, the police, the Dimapur police came to arrest him, due to which he is apprehending his arrest in connection with this case. The petitioner submits that as he has been threatened by the first informant, he is apprehending harassment if he comes to Dimapur in connection with the case lodged against him, and hence prays for issuance of an order under section 438 of CRPC. On the other hand, Mr. V. Zumumi, learned public prosecutor submits that perusal of the case diary may be necessary for consideration of the anticipatory bail application filed by the present petitioner. Hence, call for the case diary of Dimapur PS case number 43/2023. Fixing,
Next week, Lord.
not next week, give a longer date. A fixed date,
For 3 weeks, Lord.
after 3 weeks, a fixed date. Let some investigation be done.
On 24.
On fixing 24 August for the case diary. Learned public prosecutors shall ensure production of the case diary on the next date fixed. However, considering the nature of allegations leveled against the present petitioner, also considering the materials placed before this court along with the anticipatory bail application, as well as considering the submissions made by learned counsel for the petitioner, the petitioner Shri Ajay Bahadur Singh is hereby directed to appear before the investigating officer of Dimapur PS case number 43/2023 within a period of 10 days from the date of this order and cooperate with the investigating officer. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Dimapur PS case number 43/2023, he shall be, the present petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority. It is also directed that after the petitioner makes his first appearance before the investigating officer in pursuant to the order passed today, if his further appearance is deemed necessary, if his further interrogation is deemed necessary in connection with the Dimapur PS case number 43/2023, the investigating officer may interrogate the present petitioner by video conferencing.
Protection department. First appearance protection will be given, madam.
You will not be arrested.
No, I'm not saying.
No, you will be arrested but given bail.
Yes, ma'am. The other police protection may be granted to him, madam, because his threat to life is there, madam.
No. What police protection?
Without protection, he cannot come to Dimapur, madam.
No, in anticipatory bail application,
Paragraph 11 I have stated. Paragraph 11, madam. 9 and 11. 9 and 11.
Lordship, this is just a mere statement of the petitioner, Lordship. How can
Because of this matter, he has to lodge an FIR at dispute police station.
This is just a mere submission of the.
It is not only a mere submission, man. Because of this matter, they have to lodge a FIR at dispute police station. Man.
no, this statement that non-Naga is facing apprehension may not be given indulgence to. Because otherwise, the state is duty bound to protect everybody. You have been given protection.
Yes, yes.
If anything happens, you lodge an FIR.
Well, already I have lodged an FIR, madam.
No, if any incident happens, if in spite of this court order, if you see anything, you can lodge an FIR. But
from Dimapur.
no, your apprehension does not have any basis.
Also, kindly close page 69. Page 69. Well, I'm sorry, what is 70? Page 70.
Page?
Page 70, my lord. This is the FIR lodged by the petitioner for the dispute police station, my lord.
That investigation is already on before.
That is why, my lord, if the dispute police if the state of Assam is a party in this case, no, in this case it is not a party. So, my lord, some protection may be given.
Protection is already given. Interim protection under 430.
I'm asking for police protection.
You cannot ask for police protection in a petition under section 438.
Yes, Lordship, right.
You can approach state if you are apprehending
Yes, Lordship.
security, you threat to your life. If you want security cover, then you can approach state, and this instant application is not the proper proceeding. Here, whatever relief may be granted in interim, you have been granted.
Yes, Lord.
Let the possibly at online, my lord, the IO may ensure protection of the petitioner, my lord, while he appears before him, my lord. That line may be added, my lord.
No.
That can be added. IO will.
Lordship, in
as
spite
I am
of
apprehending,
serving
I am
and
apprehending my
section 41, Lordship. Time and again, Lordship, the petitioner is not for the
No,
investigating.
I am not convinced with your submission.
Yes, Lord.
You have been given protection.
Lordship.
Yes, that's the
In fact, I did not
Oh,
given protection.
In fact,
My life
that
protection, that may be ensured by the IO, my lord.
What more can
During his appearance,
the
my lord.
petitioner expect out?
Let this case be fixed after. Let this case be fixed again on 24/8.
Item number 42.
You have options available. This is not the only option.
This is also, my lord, of the similar nature, my lord, but the business transaction was there, my lord. Initially, my lord.
Same
different
parties.
my lord.
Different parties.
Different parties, my lord. But in this case, my lord, what happened? The informant, my lord, initially, my lord, filed a complaint petition before the magistrate.
Okay.
Before the magistrate. Thereafter, my lord, he withdrew the complaint petition, my lord, and while withdrawing the complaint petition, learned magistrate, my lord, acquitted the petitioner, my lord, from the alleged offence, my lord. Subsequently, the instant FIR has been lodged. So, my lord, 300 CRPC will be applicable in this case, my lord.
Here also you are seeking, you have filed anticipatory bail.
Anticipatory bail has been filed, but my lord, this case is not maintainable at all, my lord, because already I have been acquitted from the alleged offence, my lord. The same allegation, my lord, he has lodged the second FIR. Initially, it was a complaint petition. Subsequently, the FIR has been lost.
Yes, what are the facts? Tell me.
My lord, last we filed the FIR, present FIR at page 17, my lord.
Yes.
It says that, my lord, some amount of 2 crore 69,000, 85,000,
2 crore 69 lakhs 85,000 was paid to the petitioner by the informant, and in return, some articles were given and the others were not given by the petitioner. Matlab, on the same set of allegation, thus will find the complaint petition at page 23. Complaint petition, page 23.
Yes.
Same allegation, madam.
Where is the allegation?
Thus will find
Same or similar?
same manner, same amount loss will find page 24, 2 crore 69 lakhs 85,000.
And in the FIR?
FIR is also same manner.
Where is the FIR?
FIR page 17 manner. Second paragraph, fifth line manner. 2 crore 69 lakhs 85,000. Same amount. Same allegation.
Okay.
Then you also will find the withdrawal order at page 27, relevant portion page 28. Page 28, last but one paragraph, my lord. Accordingly, CR case number 6 of 2020 is allowed to be withdrawn. Along with the said withdrawal, accused Rajdeep Bhuya is also acquitted from the liability of this case. So, as long as this order stands, he cannot lose second FIR. He has to challenge this order, the acquittal order. In this case also, also will find the money receipts, from page 30 onwards.
Withdrawal is under what provision?
257,
What is 257? Whether a withdrawal under 257 amounts to acquittal. CRPC. Whether charges were...
If a complainant at any time before a final order is passed in any case under this chapter satisfied the magistrate that there is sufficient ground for permitting him to withdraw his complaint against the accused, or there be more than one accused against all or any of them, the magistrate may permit him to withdraw the same and shall thereupon acquit the accused against whom the complaint is to be withdrawn.
Okay, okay.
Then, should be kindly perused section 300 CRPC.
Yes, Mr. Zimomi.
Lordship, may kindly come to page 18, Lordship, of the order that was passed by the Chief Magistrate of Dimapur Nagari.
Page?
Page 18, Annex 3 of the petition.
Page 18 is...
Page 18.
18 is something else. It is inquiry report. Page...
Item 43.
Item 43. Item 42. 42.
Yes, yes. 42.
Lordship, page 27, Lordship. Next year 5. I may allow to read from the last paragraph. It is seen
Yes.
It is seen that the matter has been fixed for consideration of charge on 16/11 to 11/20. However, on the date fixed on medical ground, the accused person through his learned counsel had filed an adjournment petition which was allowed. Thereafter, the result of the court's order shows that the accused Rajdeep Guyan on medical ground has not been appeared before this honorable court despite summons being issued to him. Now very important also. By the order dated 11/10/2021, learned counsel advocate so-and-so appeared on behalf of the accused, Rajdeep Gujan, and submitted an application to the effect that the accused has preferred a transfer petition before the Gauhati High Court and as such pray that the present CR number 06/2020 be adjourned and kept in abeyance till the final disposal of the said petition moved before the Gauhati High Court. Accordingly, the matter was kept open. Hence, this application under Section 257 CRPC praying for withdrawal of the complaint petition filed by the complainant against the accused person Rajdeep Goyal. I have gone through the application. It is seen that till date no intimation has been received from the accused person as regard to the petition filed by the accused person before the Honorable Gauhati High Court. In the said application, it is averred that the accused person is knowingly evading the due process of law and has not appeared before this honorable court till date to face trial. This being the case, it is prayed that the instant criminal complaint petition be allowed to be withdrawn with a liberty to file afresh against the accused person. I have heard the submission of the learned counsel for the complainant and satisfied accordingly, CR number so and so is allowed to be withdrawn. Along with the said withdrawal, the accused Ranjit Goyan is also acquitted from the liability of this case, so and so, Lordship. So, Lordship, the content itself is, it says that they have, they prefer an, prefer a transfer petition before the Gauhati High Court, Lordship. So, to that, Lordship, the present CR petition may be uh, may be disposed of, Lordship. That is the contention, Lordship. However, till such date, Lordship, whether the so it has already clearly mentioned in the order, Lordship.
The transfer petition is still pending.
And then, Lordship, they are saying that simply just withdraw.
No, but pendency of transfer petition and withdrawal.
Lordship. The submission made by the learned by the accused, Lordship.
No, then that has to be seen in the this
Lordship.
criminal petition. The whether the contentions raised by the petitioner has to be looked into in this instant criminal petition. Therefore, notices are to be issued. However, yes, any interim prayer.
Instead of further, in this case, what happened, my lord? After registering the police case, they have also obtained a MBWA, which we will find at page 21. Manat Magistrate, my lord, he was aware of the alert proceeding, my lord, while issuing this MBWA. Despite the fact, my lord, this order has been issued.
So you are apprehending arrest because of this
NBWA.
NBW.
Yes, my lord. The police also visited my place, my lord, carried my house, my lord. But
In
my
both the cases,
yes, my lord.
here you have made statements. In earlier case, there was no such statement, though you
Yes, my lord.
made oral pleading.
My lord. But in view of this NBWA, also will see that police must have visited.
No, that gherawing of house. The, heard. I'm issuing notice. And here also you are having anticipatory bail application.
Yes, my lord. But my lord, in this case, my lord, the NBWA has to be stayed, my lord. If it remains, my lord, then my lord, I will not be able to appear, my lord.
Heard Mr. I.H. Soikia, learned counsel for the petitioner. Also heard Mr. V. Zimomi, learned counsel for respondent number 2. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the present petitioner, namely Rajdeep Bhuya, who is apprehending his arrest in connection with sorry. What I have dictated? Rajdeep Bhuya. Thereafter, Rajdeep Bhuya for quashing the FIR
Yes,
which was FIR which was registered in East PS within bracket Dimapur, case number 142/2023, corresponding to GR case number 369/23, as well as for recalling of the non-bailable warrant of arrest issued against the present petitioner on 24/7/2023 by who has issued? Where is the order?
Case 21, my lord.
By
CJM Dimapur, my lord.
by Chief Judicial Magistrate Dimapur in GR case number 369/2023. The issue notice to the respondents as Mr. V. Zimomi, learned additional public prosecutor, has received the notice on behalf of respondent number 2. No formal notice need to be issued to respondent number 2. However, requisite copies of the petition shall be furnished to learned public prosecutor during the course of the day by the petitioner. In respect of respondent number 1, the petitioner shall take steps for issuance of notice through registered post with AD within 3 days from the date of this order The notices are returnable within 4 weeks. In anticipatory bail application, which I will be taking up now, interim protection will be granted.
No. Not true. NBW.
However, in view of interim protection granted to the present petitioner in AB case number 30/2023, the operation of non-bailable warrant of arrest issued against the present petitioner by London Chief Judicial Magistrate Dimapur on 24/7/2023 shall be kept in abeyance until further orders. Let this case be fixed again after a period of 4 weeks. Now 44.
Motion, item number 44.
Heard Mr. I.H. Soikia, learned counsel for the petitioner. Also heard Mr. V. Zimomi, learned public prosecutor, Nagaland. This instant application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Mr. Rajdeep Bhuya, who is apprehending his arrest in connection with East PS case, PS within bracket Dimapur case number 142/2023 under section 406/420 of the Indian Penal Code, corresponding to GR case number 369/2023. The accusation in this case is that on 30/5/2023, one, who is the first informant?
FIR should find out 17 is the FIR number.
Page
17 is the FIR number.
Seventeen is not the affair. Affair is at 13.
Page 13.
That one what is the name of the first informant?
Lakshman Sumi.
One Lakshman Sumi had lodged an FIR before the officer in charge of East Police Station, Dimapur, inter alia alleging that the first informant came into acquaintance of the present petitioner, namely present petitioner, who introduced himself to the first informant as the managing director of Messrs. Plane Craft, located at 6 Mile, Gauhati, and during the course of acquaintance with the present petitioner, the first informant was given an assurance that if he invests for arrangement of purchase of commercial vehicle, flats and plot of land at Gauhati at a reasonable price, the present petitioner would help the first informant, and accordingly the first informant had invested an amount of rupees 2 crore 69 lakh 85,000 on various occasions. However, after the payment of the said money, the present petitioner has not kept his promise and has committed criminal breach of trust and as well as cheating. It is criminal breach of trust and cheating. Stop. On receipt of the said FIR, East Dimapur PS case number 142/2023 has been registered. Learned counsel for the petitioner submits that. Now, what is your submission regarding allegations made against you?
Submission is that on page 21 onwards, we will find the money receipt, which was signed by the informant himself while receiving the articles. Customer signature is there, madam. Page 21 onwards, madam.
What are these? But the allegation is that you promised to give flats.
Also, you find a statement, page 37. Some amounts are outstanding. That is true, my lord. That is admitted. My lord, he paid 2 lakh 69, 2 crore 69 lakhs 85,000. And my lord, articles amounting rupees 2 crore 32 lakhs 94,000 was delivered. Some amount is, my lord, outstanding. That is true, my lord. I am ready to pay that amount also.
Learned counsel for the petitioner submits that it is admitted that the present petitioner received an amount of rupees 2 crore 69 lakhs 85,000 from the informant on various occasions, and against this said receipt of amount, he has supplied what you have supplied. The vehicles also.
Vehicles also, madam. Vehicles and advance payment for the flats,
Yes.
and other motor parts,
He has supplied vehicles and other articles to the first informant to the tune of rupees. Where is the? To the tune of rupees 2 crores 32 lakhs 94,000, and only 36 lakhs 91,000 remains outstanding, which the petitioner is ready to pay to the first informant. It is also submitted by the learned counsel for the petitioner that with regard to the same matter, the first informant had earlier lodged a complaint case before the Court of Learned Chief Judicial Magistrate Dimapur, and by order dated
7/12/2021,
7/12/2021, passed in CR case number
6 of 2020.
6 of 2021,
6 of 2020, madam.
It is 6 of 2021 mentioned in the order. Look,
21, I'm sorry.
6 of 2021. Learned Chief Judicial Magistrate Dimapur had allowed the withdrawal of the said CR case and had also acquitted the present petitioner in the said case. Stop. It is submission of learned counsel for the petitioner that the after acquittal under section 257 of the Code of Criminal Procedure, he may not be prosecuted again for the same matter as he is protected by section 300 of the CRPC as well as article section 300 of the CRPC, and accordingly he has also preferred a criminal petition which is registered as criminal petition number 18/2023. 18/2023 in stop. Now, the learned counsel for the petitioner further submits that in the meanwhile, after filing of the FIR, the Dimapur police have obtained a non-bailable warrant of arrest against the present petitioner, which is where is the order?
I have not annexed the bail application, madam.
Then why are you apprehending?
24/7, madam. 24/7.
Statement you have made. Statement you have made in the anticipatory bail application that warrant of arrest has been issued.
Yes. Both matters will be connected, madam.
No, it may be connected, but in an anticipatory bail application, you have to place the materials on which you are apprehending your arrest. Where are those materials? Where is the statement that you are apprehending arrest? And what is the basis of that statement?
Page 7, madam, paragraph 10. What makes some statement, but not NBW.
Now the present petitioner is apprehending his arrest. There ought to have been statement in the anticipatory bail application that warrant has been issued. Though you have mentioned this in
The criminal petition.
criminal petition. Yes, Mr. Zimomi. Otherwise, the NBWA has been
State by Lordship.
kept in abeyance in interim.
Lordship, this AB number 30/2023, Lordship, is altogether a different issue from the earlier this case, Lordship. Here is a case where Lordship. Uh,
No, he is apprehending, but he has not explained in so many words, which should have been there.
Lordship.
Yes, I beg of Lordship for it.
Apprehending arrest. What is the last line? And he is and therefore he is apprehending arrest. Stop. Learned counsel for the petitioner has also submitted that in the criminal petition filed by the present petitioner, which has been registered as criminal petition number 18/2023, the non-bailable warrant of arrest issued against the present petitioner has been stayed in interim till which date? Till further order. Until further order. Stop. Now what is your submission, Mr. Zimomi? Case diary would be required.
My lord.
We will call for the case diary.
Lordship.
Heard Mr. Learned, Mr. V. Zimomi, learned public prosecutor, submits that perusal of the case diary may be necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary fixing same date. Fixing, what was the date?
24/8.
Fixing 24/8 for the case diary on which case diary learned public prosecutor shall ensure production of the case diary on the next date. However, considering the facts as narrated in the anticipatory bail application, as well as also considering the fact that the non-bailable warrant of arrest issued against the present petitioner has been kept in abeyance in criminal petition number 18/2023, as well as considering the submissions made by learned counsel for the present petitioner, the present petitioner, namely Rajdeep Bhuiya, is hereby directed to appear before the investigating officer of East Dimapur PS case number 142/2023 within a period of 10 days from the date of this order and cooperate in the investigation. If he does, after full stop, if he does so within the stipulated period of time, in the event of his arrest in connection with East Dimapur PS case number 142/2023, he shall be allowed to go on bail of rupees 30,000 to the satisfaction of the arresting authority. He shall be allowed to go on interim bail of rupees 30,000 to the satisfaction of the arresting authority. Let this case be fixed again on 24/8/2023.
Deep love. I'm sorry for the statements which I have not made in the application.
Ultimately, you got the.
I'll file the petition with Marathon so that Marathon the next day this Lekuna is not there.
Yes.
For admission, item number 15.
Item number
15.
16.
15.
One. Yes.
We have this Lordship.
Yes.
Lordship, during the pendency of this contempt petition, the orders passed by this Honorable Court in the contempt petition on 5/12/2022 as well as 14/3/2023 has been violated by the respondents. Now, Lordship, to appreciate the issue, kindly allow me to highlight the facts briefly so as to not appreciate the case. My Lord, the present petitioners, the village cards. Village cards. My Lord, we are performing the duties in the 6th, my Lord, it is a self-defense force. Now, my Lord, can you allow me to give a brief gist of the history so that before I go to the documents, your Lordship will appreciate my submissions relying on the documents. Now, Lordship.
How many petitioners, contempt petitioners?
My Lord, it's an association.
Village Guards Association.
Yes, now presently, Lordship, their personals are serving in the 6 bordering districts of Nagaland is numbering around 9,508, if I remember correctly. My Lord, yes, it is 9,508 employees, and it's a George association, which is a registered association. They have been agitating their case. Now, my Lord, besides performing their duty of defending or protecting their villages, my Lord, they are given arms training and they are issued arms by the police, by the government. These are under MH. Now, my Lord, besides protecting their village, my Lord, they perform law and order duties in aid of police and civil authorities. They perform law and order because Lordship in the boundary area there is no sufficient police station, so they perform their law and order and other duties like election duty, ROP, and all that in aid of police and civil authorities. Also, my Lord, they perform the duty of anti-insurgency duties, my Lord, in aid of security forces. Lordship, the petitioners have a very glorious history. My Lord, many of the petitioners are winners of Ashok Chakras.
Is it?
They are not ordinary, my Lord, they are not ordinary people. In fact, in the judgments also you will find they are winners of Calendar Award, the highest Calendar Award in the country, Ashok Chakra, as well as Presidential and Governor's Medal. Now, my Lord, they were paid a fixed honorarium of rupees 1,500 only. So, my Lord, they approached this Honorable Court, initially making a prayer that at least the minimum wages should be made available to them. I mean, Lordship imagine a winner of a Calendar Award of Ashok Chakra paid 1,500 rupees fixed per month. So we filed a writ petition, and then we prayed that, look, can you give us minimum wages? Then, my Lord, what has happened? During the pendency of the writ petition, the Honorable Supreme Court passed a judgment called, my Lord, the judgment is known, it is popularly known as Gra Raksha, Home Court's case. My Lord, then 2015, 6 SCC 74247. Now, what has happened in this case? My Lord, all are reflected in the judgment, but for easy understanding, what has happened in this case? The home cards, one of the home cards are, your Lordship is well aware everywhere the home cards. It is a voluntary service, they are not regular employees. the approach of local Supreme Court, home guards from Delhi, Himachal, and others.
The 2015 case.
Yes, 2015 case.
Okay.
2015 case.
They are different home guards, not the present petitioner.
We are village guards.
Okay.
They are home guards.
Okay.
So, Mother, the home guards are guarding the residential buildings of VIPs and performing traffic duties in the rural urban areas. Now, what has happened is the home guards from Himachal Pradesh as well as Delhi, they are also voluntary service. They approach Honorable Supreme Court for regularization of their services. Though the Honorable Supreme Court rejected the writ petition on the ground that they are not holding any substantive post, so their regularization was rejected. However, Lordship, the Honorable Supreme Court in paragraph 39 of that particular judgment says, since the home guards, while performing their duties, they are performing the duty of a policeman.
Okay.
Well, they may perform the duty 1 day, 1 month, 2 weeks, as a different issue. They sit at home. Home guards also sit at home and they perform their duties. But Honorable Supreme Court's test of to determine by the Honorable Supreme Court was, since the home guards were performing the duty of a policeman, when they performed the duty, they should be paid salary of a policeman, constable for 30 days in a month. So that direction was given. Accordingly, Mala, they were not regularized, no regularization, but salary of a constable was paid on that premise. So, Mala, we amended the writ petition, saying that since we are also performing the similar nature of work and we are voluntary in nature, we also should be paid the salary at par with the home guards, since we are performing.
Your original WPC was registered as?
My Lord,
WPC number?
Lordship, can you bear with me? 33 of 2017, WPC 33K of 2017. And a judgment was passed on 9/11/2017.
This writ petition you preferred after that?
My Lord, during the pendency.
No, home guard case of Supreme Court.
But the judgment order effect was during the pendency of the writ petition.
Therefore, you amended.
Yes, we amended, and then we prayed that, look, in view of this, we also perform similar nature of duty, that we perform the duty of a policeman. Somebody, my Lord, who has been awarded Ashok Chakra, at least I'm doing some similar nature of works, because many of us have sacrificed our life fighting insurgency. Now, Lordship, accordingly, my Lord, the single judge of this honorable court, my Lordship, he kindly come annexure A, page 16 to my contempt petition is the judgment of the writ. It is judgment in the writ appeal 29/1/2021.
What was the fate of the writ petition filed by you?
My Lord?
The writ petition which was 33/17.
Yes.
What was the fate? What happened in that writ?
My Lord, it was a lot. I'm coming to that.
Okay.
My Lord, the judgment is annexure A, division B. My Lord, at paragraph 14 at page 23. Page 23 to the contempt petition. My Lord, it is reflected by the single bench. My Lord, may I read paragraph 14? The learned single judge, upon considering the case projected by rival parties, disposed of the writ petition for impugned judgment dated 9/11/2017 by directing the state government to examine and raise the existing wages in the allowance of village guards to a reasonable level, but not less than that of home guards of the state within a period of 2 months from the date of receipt of a copy of the judgment in order. The learned single judge further directed the increase in wages in allowances should be made effective from 1/1/2017, thus being highly aggrieved, the state respondents had filed instant appeal as with appellants. Mention will be made here that when the writ appeal was taken up for admission on 7/2/2019, this court was of the view the Union of India and the Ministry of Home Affairs would be a necessary party. As such, the Union of India be met as respondent number 7 in the writ appeal. Accordingly, they were met. Well, may I continue?
At 2, we will continue.
Yes. Right.
Mr. Lordship,
Yes.
please allow me to mention item number 31.
Yes.
The government have not yet filed your affidavit, my lord.
Lordship, I am not in this matter. I'm told that my colleague Supong is attending this matter, Your Lordship. 3 weeks time, I can't be granted.
Heard Mr. Akineri Chabo, learned counsel for the petitioner. Also heard Mr. N. Angami, who is submitting on behalf of Ms. S. Supong Chang, who is appearing for the state respondent, and prays for 3 weeks' time for filing a affidavit in opposition. The learned counsel for the petitioner does not object to this said prayer, hence same is allowed. Let this case be listed after 3 weeks accordingly.
Lordship, I like to mention item 37 on behalf of my colleague S. Mary, Your Lordship. Due to some personal difficulties, Your Lordship, she has to.
Heard Mr. N. Angami, learned senior government advocate, who submits that the government counsel defending the present case, Ms. S. Mary, has some personal difficulty, and on that ground an adjournment is paid for today. Mr.
Benizon V.
Benizon V. Choi does not object to the said prayer, hence the prayer is allowed. Let this matter be listed accordingly after
A week, my lord.
After a week.
Deeply obliged.
Yes.
Unlisted motion for admission item number 46 and 47.
Yes, Lordship. Lordship, I have instruction from the petitioners to withdraw the petition, Lordship.
Heard Mr. Foseco Forte, learned counsel for the petitioner, who submits that he has instructions from the petitioners to withdraw the instant writ petition. Considering the considering the submission made by learned counsel for the petitioner, the prayer is allowed. This case is dismissed on withdrawal.
Lordship, there are two matters.
Both same order.
Yes, Lordship. And Lordship, there are some interim orders may be vacated.
Automatically, the interim orders granted earlier stand vacated.
Lordship, may kindly give us liberty if
he seeks in earlier line mentioned, seeks permission to withdraw with liberty to file afresh. The prayer is allowed. This case is dismissed on withdrawal with the liberty as sought for granted.
Item number 15 will be continued.
Lordship, so paragraph 14, page 23, by the judgment and order dated 9/11/2017, in the learned single bench allowed the writ petition with the direction that he should be paid, wages should be revised with the wages, wage cards not below that of home cards with effect from 1/1/2017. That was the direction at page 23, paragraph 14. And Lordship, by paragraph 15, within the MHA was not a party before the single bench. The division bench deemed it fit that he should be implemented as a respondent at paragraph 15. Now, my Lordship may come to paragraph 29, page 33. The division bench only modified the judgment.
Page 33.
Page 33, paragraph 29. This is the last page of the. Second last, married, my lord, only one paragraph.
Yes.
In that view of the matter, we direct the state government to constitute an expert committee to examine and determine, my lord, examine and determine the payment entitlement of the financial benefits of the BGs in consultation with MHA. The expert committee should include representatives from Home Department, ENR, Finance, at least 2 members from the Petitioners Association, representatives of MHA. The committee should be chaired by an officer not below the rank of Additional Chief Secretary to the Government of Nagaland. The committee should be constituted as directed here and above within a period of 3 weeks from the date of receipt of certified copy of this order, and committee should complete the process of examining the matter of enhancement of the honorarium and other allowances of the BGs as expeditiously as possible and not later than within 4 months from the date it is constituted. While considering the matter of enhancement of the honorarium and other allowances as directed here and above, the committee shall take into consideration the observation and direction given the apex court in paragraph 39 of the Crown Raksha Home Guard Welfare Association Supra. The recommendation by the committee shall be done forwarded to the state government in the Home Department and also the Ministry of MHA for approval and further necessary action. So the committee to recommend, the committee to determine, examine and determine the enhancement, and paragraph 39 has to be taken into consideration and put up to the state government in the MHA for approval. Then thereafter, Lordship, page 39. In compliance, the first committee was constituted on 14 April 2021, and actually D page 29 by the Chief Secretary. Now, my lord, Lordship may kindly read the terms of reference. The committee shall examine and determine. The committee should take into the consideration of the para 39, and committee shall submit its report within 3 months. My lord, para 39 I was talking about performing the duty of a policeman. Now, thereafter, Lordship may kindly come to affidavit in opposition filed by respondent number 3.
In the instant.
Yes. Affidavit in opposition on behalf of respondent number 3.
Respondent number 3.
The commissioner who is the commandant general of the village guards.
Just. Yes, respondent.
On page 12. This is purported, this is the compliance file. My lord, Lordship may kindly see the take note, page 12. My lord has found it?
Yes.
Minutes of the meeting of the expert committee to examine and determine the entitlement held on 31 January 2022. Now, Lordship may kindly come to page 13. To save time, I'll only go straight to the recommendation. Page 13. I'll read paragraph 2. Thereafter, the chairman requested the...
Where are you reading? Page?
Second paragraph.
CD. Oh, 2, okay. There.
Thereafter, the chairman requested the members to give their views in comments on the matter which are recorded as under 1. The Special Secretary Finance highlighted of the present economic scenario and the financial position of the state. In that sense, the imposition of the COVID-19 lockdown, the state's financial position is not favorable. In view of the above, the present proposal of BGs for further increase in salary at present is not possible. Then, 2, the Home Commissioner also stated that since bulk of the expenditure incurred for remuneration of BGs are being borne by MHA and they have expressed their inability to increase the same, it would not be possible to consider proposal at present. Lordship, may kindly go back to next page, paragraph 14, the recommendations. Page 14, this last paragraph.
Yes.
These are bygone decisions. I'm just trying to highlight to your Lordship. After further discussion on the issue of the enhancement of the honorarium of BGs and other allowances their demands, the committee in agreement agreed in principle to look into certain demands, and Commissioner and Commandant General Village Guard Organization Nagaland was interested to examine those demands and take them better forward. Those demands are under 1, enhancement of provident fund to the deceased person, DADA, grants of rewards and awards for heroic deeds. So, my lord, the salary was not considered. Review of salary revision was not considered.
Okay.
Then, my lord, then this contempt petition, now Lordship may kindly come to the judgment, the order dated 5/12/2022 passing. This Lordship may kindly see the order dated 5/12/2022 by this court. Lordship has found it?
Yes.
I'm reading from paragraph, I'm reading from paragraph 5. My lord, just to save time, I'm reading from paragraph 5 of the order. My submission, starting from my submission. Paragraph 5. May I, Lordship?
Just a minute. Paragraph, it is a long order.
Mr. Taka, starting from Mr. Takamasa, that is senior counsel.
Yes. Yes, paragraph 5.
May I read, my lord?
Yes, please.
Mr. Takamasa, then a senior counsel appearing for the petitioner submitted that respondents have not taken the direction given in both the orders passed in the writ petition in the writ appeal seriously, thereby have failed to take the matter forward in the right direction. He also submitted the representatives of the MHA for whom the lion's share of the funds come from has never participated in the 3 meetings. And the state respondents also have failed to take up the matter that the Home Ministry in earnestness as required in the direction given in the 2 judgments passed by the writ court and the division bench. The learned senior counsels further submitted that respondents totally misunderstood or have not properly understood properly the judgment passed in both the writ petition and the writ appeal. Therefore, appropriate order from this court is called for, so that you are compelled to act and deliver as per directions given. Mr. further submitted that though it was clearly mentioned in the judgment of the division bench that the contents of the paragraph 39 of the judgment be taken into account while considering and determining the appropriate honorarium of the village guards, but the respondents never did the same. Lastly, the learned senior counsel referred to the judgment such and such, submitted that partial compliance to an order of a court is not compliance at all. Therefore, a fresh direction may be given to respondents for full compliance for direction given in both the judgments passed in the writ petition and also in the writ appeal by giving specific time for compliance. Mr. Jamir, the learned counsel appearing for respondent number 3, by relying on paragraph 5 of the affidavit of the respondent number 3 itself submitted, that told the committee was constituted consisting of 8 members, representative from the MHA, the representative for one reason or the other could not be present, in his view could not be obtained through VC, though efforts were made. Therefore, a letter was sent to the MHA for obtaining the same. As per the review received through a letter dated 14/12/2021, it appears that MHA is not willing to enhance the money honorarium of village guards due to paucity of funds. Lord, may kindly take note of this. Due to paucity of funds. Therefore, the state respondents, including the respondent number 3, could not take forward the matter to the directions given in the writ petition and in the writ appeal. Mr. Jamir submitted that the respondents number 3 in the state respondents, at least on their part, have tried to comply with the directions given in the writ petition and the writ appeal, have not fallen short of full compliance because of the view expressed by MHA. Therefore, if this court in its wisdom feels the respondent should further comply with the directions given, the state respondents will be given another chance to do the same. My lord, this may be kindly taken note. Lastly, Jamir submitted that by constituting the committee and by conducting the meetings, the state respondents have shown that they are willing to comply with the directions given the writ petition and the writ appeal, so no willful disobedience has been committed by them. Besides having submitted as above, Jamir submitted that in this case, in case this court directs a respondent to continue to take appropriate actions as required in terms of the direction, the state respondents will be given time to reconstitute the committee, since some of the committee members have retired and some of them have gone on deputation out of state. Mr. Such and such, appearing for respondent 2, 4, and 5, adopted the submission of such and such in respect of respondents' representative from them. My lord, this is operative. From what has been stated above and the contents of the minutes of the meetings and the action taken so far by the respondents and the respondent number 6, it appears that the directions given in the writ petition and the writ appeal have not been gone into in depth to understand the same and their implications. Further, from the steps taken so far as may be seen from the meeting minutes, it appears that there is lack of concern and wholeheartedness in dealing with the issue. The appellate court directed constitution of the committee so that the issues involved in the implications thereof are deliberated thoroughly, so that the grievance of village guards whose service have been acknowledged and uploaded by Bimini, including the President of India, may be settled in equitable and just manner. These people, as per the records, who have awarded class 1 Ashok Chakra, 8 class 2 Ashok Chakra, and 5 class 3 Ashok Chakras, besides other awards. From the letter of MHA, it appears that the judgments passed in the 2 cases have not been perused at all, and therefore have refused to grant any benefits to them just on the ground of paucity of fund. Paucity of fund was never an issue before the Red Court and therefore before the division bench. In any case, paucity of fund cannot be a reason for denying entitlements, especially persons like village guards, whose service have not been only acknowledged but applauded by so many awards and citations. People who are serving the country in difficult places in difficult times should be given their due because their services kept the people of the country safe and sound. It must also be remembered that the people of this kind of group hardly bring their grievance to the higher authorities for redressal. Most of the time, they keep quiet, but only under compelling circumstances they come forward to plead their grievance. Therefore, people in authority who are concerned with the affairs of such persons should be more sensitive or sensitive enough to attend to their grievances at the earliest, without giving them further or without giving them any further or without pushing them to the wall. From the records as stated above, it appears that the state's respondents have taken some steps. Therefore, this court is of the view that they have not at least deliberately ignored or neglected compliance with the direction given. Therefore, respondent number 1 is once again directed to reconstitute the committee in the light of the submissions made by TB Jamir and other councils representing the other parties within a period of 1 month from today. After being constituted, the committee shall have their deliberations and determine the benefits to be given to the petitioners in terms of direction given in the writ petition and the writ appeal. The whole, my lord, this is important. The whole exercise should be completed within a period of 4 months from the date of constitution of the committee. The chief secretary, number 1, shall thereafter file a compliance affidavit. So, my lord, direction was given to reconstitute, reassess, and full compliance within a period of 4 months from the date of reconstitution of the committee. Now, my lord, these people are the lowest of the low people. The villagers are Toinsang, Mong, Kifri, Longling, my lord, the most backward areas, the ordinary people there, how they have been sacrificing for the country throughout the years. Now, Lordship may kindly see read the order 14-3-2023. 14-3-2023.
Yes.
Mr. Angami, Learned Government Advocate, appearing for the respondent, has furnished a notification dated 28-2-2023 by which an expert committee has been reconstituted in terms of the order dated 5-12-2022 passed by this court in the present contempt petition. After considering the notification, the expert committee is directed to proceed in terms of the direction passed by the division bench of this court within a period of 3 months from the date of reconstitution of the expert committee. Therefore, the chairman of the expert committee, Mr. Sendiyama, Additional Secretary, IAS Additional Chief Secretary to the Government of Nagaland, who is the chairman, respondent number 2, shall file compliance affidavit on or before 5th June 2023. My lord, the limitation, Lordship may kindly see the committee was reconstituted by a notification dated 28 February 2023. Lordship, the copy has been furnished to this honorable court. So
in person to the direction of this court in this contempt
yes,
case. Okay.
So, my lord, that is to be the whole exercise to be completed within 4 months from the date of constitution of the committee. That is the direction. in 2022 order, Lordship. Last paragraph, paragraph 9.
Yes.
So, my lord,
So by this calculation, they should have complied with within 30th of June.
yes, that has not been done. No application has been filed by the respondent for extension of time. Normally, Lordship, when certain time-bound direction is given, if they are not able to comply, my lord, they should have filed an IA for praying for extension of time, expressing their difficulties. That has not been done. So, my lord, the respondents are already further in violations of the order of passed on 5/12/2022 as well as 14/3/2023. These two orders have been further violated because no time-bound direction has been given. They have not complied. No prayer, no IA, nothing has been filed for extension of time beyond the 4 months time. So, my lord and lordship, the committee, according to my information, the committee, the reconstituted committee, 2 meetings was held on 19/5/2023 as well as 13/6/2023. 19/5/2023 and 13/6/2023. And in my respect, because my lord,
This is not on record.
No, my lord.
Okay.
I'm making submission because my lord, they are supposed to, because my lord, in the committee, 2 representatives from the petitioners are also participating.
Okay.
So they have information because since they are members of the committee. So 19/5/2023, 13/6/2023, my lord, 2 occasion meeting has been held, and the information, the instruction I have received so far is not good. It appears their committee is simply reiterating their earlier decision. So that is for the committee to decide. That will be decided by this honorable court as and when affidavit, compliance affidavit is filed. So my respectful submission, my lord, at this stage, lordship, a notice show cause an order to be in order this honorable court may finally pass an order as to why appropriate proceeding should not be initiated against respondent number 2 for the members of the committee for violation of the 2 orders. As of today, my lord, they are in clear violations of the order dated 5/12/2022, because which gives 4 months time from the date of reconstitution. Then, my lord, 14/3, my lord, there is specific direction.
Otherwise, a contempt proceeding is pending. This contempt proceeding is pending.
Is pending. This contempt proceeding is pending. But the point I'm making is because it is unique of its kind, because in view of the Honorable Supreme Court judgment, partial compliance is no compliance with this Honorable Court gives direction. That 4 months time you comply and you file compliance affidavit. 4 months from the date of constitution. Till date, nothing has been done. So, my lord, an order has been issued. Direction has been issued upon the respondent number 2. Lordship, the name is also mentioned in the 14.3 as to why appropriate proceeding should not be initiated. It should not be initiated against him or against the committee for violation of the 2 orders. 5/12/2022 and 14/3/2023 has been violated, my lord, further violated. So, contempt or non-contempt?
The contempt has not been done by the committee members. It is by the state respondents only.
My lord,
state respondent constituted the committee.
My lord, the state respondent, Lordship, may kindly see the 14/3/2023 order.
Yes.
There's a specific direction. Lordship, may kindly see 14/3/2023 order. This honorable court directed the chairman of the expert committee to file the compliance affidavit on or before 5th June. So the 2 orders has to be read together. State government, Lordship, as directed, the chief secretary has already reconstituted the committee. So the state government, so the chief secretary.
Committee will submit its reports to state government, not.
Exactly. But this committee is sitting over it. That is why on 14.3, the committee chairman was specifically directed to file the compliance on or before 5/6/2023. That is the issue. Initially, Lordship may kindly appreciate.
Thereafter, Chairman, Expert Committee.
Lordship may kindly appreciate this.
Otherwise, the chairman of the expert committee is not a party to this.
No, my lord, he's respondent number 2.
As additional chief secretary
Yes, as additional chief secretary, Lordship may kindly see the. Your Lordship may kindly see the head notes.
or as member of the committee.
Lordship may kindly see my content. Lordship may kindly see page 3.
Yes. As chairman of the expert committee.
Yes. Lordship may kindly appreciate this. Initially, on the first order, 5/12/2022, this committee directed, this honorable court directed the
Constitution of an additional committee.
to reconstitute the committee. Accordingly, in compliance, the chief secretary, who is the respondent number 1, has already complied, and committee was, Lordship, the committee was reconstituted. Lordship, the committee reconstitution order is already put before your Lordship, 28 February 2023. So, my Lord, that way, the respondent number 1 has already complied with his duty as directed on 5/12/2022. And in view of non-compliance by respondent number 2 onwards, this honorable court on 14/3/2023 has given the second direction. And they are sitting on it.
Otherwise, this newly reconstituted committee had to give its report to the chief government,
my Lord,
not to the court.
My Lord, no.
Only compliance is to be given to the court.
Yes. So in the compliance, what report has been submitted has to be placed. That is the compliance, Lordship.
That we have submitted the report.
Exactly, and a copy of the report. Because compliance means the copy of the report has to be submitted before the honorable court to show that they have complied.
That is not mentioned.
That is not been done, my Lord. Now, my Lord, these are poorest of the poor people. Lordship may kindly.
Now your prayer is to
3,000. During the pendency, my Lord, when the MHA was, during the pendency of the writ petition, MHA was kind enough to enhance it to 3,000, so we are enjoying 3,000.
That I have understood. That issue is already handled by the court.
Yes.
That a committee would consider all these aspects.
All these aspects, Lordship, yes.
And as the committee constituted earlier failed to consider the issue of payment of salary, enhanced salary, a committee was reconstituted.
Yes, payment of honorariums. Yes.
Honorarium.
Yes. So that they are sitting on it.
Okay. Now your grievance is as per direction of 14/3/2023. The expert committee has not filed a compliance affidavit.
My Lord, as per direction of order dated 5/12/2022 and 14/3. Lordship, it has to be read together because 14/3/2022 is an offshoot of 5/12/2022 because 5/12/2022 is the basic order. Passed by this honorable court for reconstitution of the committee and to submit within 4 months. Since that has not been done, this order was passed.
Okay.
My Lord, poorest of the poor people who has sacrificed their lives for the country and who were paid initially, my Lord, they started the salary with 50 rupees in the 50s, then it was enhanced to 500 rupees. From 500, it is enhanced to 1,500. Lordship, even 3,000 rupees is below the minimum which is act being paid to the employees of the state. Lordship, minimum wages is 5,000 plus in the state, even today.
Yes. Yes, Mr. Hings.
Please, Your Lordship.
You have completed your submission.
Yes.
Now, your prayer is to.
My respectful submission and now is that, my lord, because, my lord, it is a contempt petition. So my submission before this honorable court is, my lord, an order may be passed directing the respondent number 2,
Why contempt proceeding should not be
where
initiated.
appropriate proceeding should not be initiated for violation of the 2 orders, 5/12/2022 and 14/3/2023. Then only they will wake up. Unless little electric shock is given, my lord,
Yes,
he will not
Mr.
wake up from their slumber.
Mr. Imsam.
Your Lordship, I just, only last week, initially it was handled by some other advocate. And last week I have handed over the file. So I cannot say anything about the merit of the case. But the thing is, in order to comply the direction of the Honorable Court, I'm praying to Your Lordship to give some more time to me to take step so as to comply the direction of the Honorable Court.
No, but this direction was clear direction.
Yeah, yes. Your Lordship, I am very much on receiving the report from earlier council. I am very much aware of the order dated 29/1/2021, that is the WA Rate Bill 1 and 28, and order dated as pointed out by our learned colleagues, 5th December 2022. In this contempt petition, I also have gone through, and another order 14 March, that's also I've gone through. Then again, last order was 8 June, I've gone through. But since I am appearing the first time in this matter, so in order
No, but
to
somebody
comply-
was there for the government.
My lord, you see, formally we were informed that instruction is coming. So, my lord, on 8 June when the matter comes, I don't want to jump on the issue, my lord. I thought that the good sense will prevail, and but before the next day, we also have received some communication from the Commandant General that you will be filing the affidavit on or before 4th August. So, my lord, we waited.
Okay,
Because I didn't want to fight with them. We are poor people. That's why we patiently waited till today, hoping that they'll do the needful asam today. Having no option, I have to raise this issue. Otherwise, my lord, there are ghosts, and why should we confront them? But we are compelled. And Lordship may kindly appreciate. Lordship may kindly appreciate, unless an IA is filed, further submission, this honorable court did not give time. It has to be if at all, my lord, he wants extension of time, he should come through proper form, not the oral submissions.
Your Lordship, I'm first time appearing before Your Lordship in this matter. So unless time is granted and take the appropriate step, I cannot go at the time from today. So that is my humble submission. And it doesn't mean that the majesty of the honorable court is not disregarded. But who knows? I cannot say anything about the merit. But Your Lordship, since it's the first time, so a time will be given. Let me take step. Being a court officer of the court. So let me assist the court at the same time to comply the direction of the honorable court. So unless the time is given, then the presence, my appearance, it doesn't give any meaning.
Let
It
him
doesn't
file.
give any significance.
Let him file appropriate. What prevents him from filing appropriate petition?
Then unless the time is given, I cannot take this step. So let me, Your Lordship, my humble submission is, let me take some steps just to acknowledge the majesty of the honorable court. Unless time is granted to me, then I cannot take step. Then my presence before Your Lordship will have no significance at all. And the thing is, throughout the proceeding, it was sent by some other council. And today is the first appearance, my appearance. So
No, but
as a
the state response very intelligently they have changed the council so that you get that plea.
No, it's not
because they know they are in trouble.
Heard Mr. Takamasa, learned senior counsel, assisted by Miss
Tia
Kamla, learned counsel for the petitioner. Also heard Mr. Imti Imsong, learned additional advocate general, appearing for the contemners. Learned counsel for the
Your Lordship, respondent number one, I'm representing the respondent number one.
Appearing for Mr. Imtim Song, appearing for
Respondent number 2.
respondent number 2. Respondent number 2 means
The chairman.
Chairman of the committee.
respondent number 2. Stop. Miss.
As far as our part is concerned, as my letter chief has already said, we were asked to, we were directed to form a expert committee.
That has been.
That we have already complied by, and then we have got it to the notice of this court by placing notification letter 28 February 2023. So we have already complied with the order of the court.
Also heard Mr. N. Angami, learned senior government counsel. Learned, stop. Learned Mr. Takamasa, learned senior advocate for the petitioner, submits that by order dated 12 by order dated 5/12/2022, this passed in this instant contempt case. This court directed the where is the operative portion? This court directed the state respondent to reconstitute the committee.
May I please sorry for the interruption. If your lordship may, for the benefit of the respondents, if paragraph 8 in 9 is reproducing the order, that will be, I'll be highly obliged.
This court directed as follows.
Paragraph 8 in 9.
Court paragraph 8 and 9 from order dated 5/12/2020. Thereafter, it is further submitted that thereafter on 14/3/2023,
That order also may kindly be quoted for the benefit of the respondents.
this court further directed as follows. Direct the entire or
Yes, please.
14/3.
So for the benefit of the respondents, lordship.
However, Mr. Takamasa further submits that though in pursuant to the direction passed on 5/12/2023 and the expert committee was reconstituted with respondent number 2 as its chairman. However, as directed by the order dated 14/3/2023, the respondent number 2 has not filed any compliance affidavit within the time prescribed in the said order.
And no IA filed for extension of time.
Neither any interlocutory application has been filed for extension of the time for compliance of the said orders. It also appears that after the said order, it also appears that almost 2 months have lapsed since the time limit, since 5/6/2023, which was the time within which the respondent number 2 was supposed to file the compliance affidavit. Stop. On the other hand, learned additional AG, Mr. Imtim Song, has submitted that he has been engaged in this case for the first time, and he is appearing in this case for the first time today only, and earlier this case was handled by some other counsel, and on that ground he prays for some time to take necessary steps required to comply with the direction passed on 14/3/2023. It, it appears that the the order dated 14/3/2023 clearly mentioned the outer limit as 5/6/2023, within which the respondent number 2 was supposed to file the compliance affidavit. It also appears that thereafter this matter was listed on 8/6/2023 and then today. However, except the oral submission made by learned additional Advocate General, no steps have been taken by the counsel who was defending respondent number 2 earlier in this case. Hence, prima facie, there appears to be non-compliance of the direction passed by this court on 14/3/2020.
As well as 5/12, Lordship.
As well as 5/12/2022. Unless the court's orders are implemented and efficacious and followed, the efficacy of court's order would not be there. And in view of that, the respondent number 2 is hereby directed to show cause as to why appropriate proceeding shall not be drawn up for non-compliance of the order dated 5/12/22 as well as 14/3/23 passed in this instant content petition within a period of 4 weeks from today. It is expected that before the next date fixed, before the next listing of this case, the respondent number 2 shall comply with the. It is also expected that before the next date fixed, before the next listing of this case, the respondent number 2 shall comply with the order of this court passed on 5/12/2022 as well as 14/3/23.
Much obliged, Lordship.
Let
Lordship,
this,
kindly give us a date.
let this case be fixed again on after 4 weeks. Yes, you suggested it. Mr. Im Song suggested it. Because you will be in trouble.
Yes. First week of October. First week of September, no, sir. Lordship, any date in the first week of September? In the first week of September.
4th.
Or what, 11, maybe a little more than.
Lordship,
Fix.
11.
Let this matter be fixed again on
Monday.
11th on September.
Much obliged, Lordship.
For admission, item numbers 17 to 19.
Next, Lordship. Lordship, we kindly peruse order dated 4/11, 11/4/2023. 11/4/2023. Lordship, this honorable court has 11/4/2023.
Yes.
I sent notice to the respondent before to engage the council. Lordship, till date, they have not engaged the council, Lordship. The respondent before is the Lok Ayutta.
Now what is to be done? Whether notice were issued? No, earlier it was, respondent number 4 was represented.
Yes,
Respondent number 4 or 5? It is respondent number
4. The Lok Ayutta.
Respondent number, it is respondent number 5 mentioned in the order.
Lordship, it is 4.
But you read the order, you have order that heard Mr. N. Muzoi Learned Counsel, who submits that earlier he was representing Nagaland Lok Ayutta. However, no extension has been granted. So he no longer represent respondent number 5. No mention about, it is wrongly mentioned, I think.
Lordship, this stage, Lordship, if Lordship may direct the registry to send another reminder to respond 4 to engage the council in these 3 matters, Lordship.
Yes. What is the matter otherwise? You have challenged?
Challenge the action of the respondent 4, whereby the respondent 4 recommended for.
Mr. Angami, you are representing respondent number?
It should be 1, 2, and 3, Your Lordship.
1, 2, 3, and 5 and 6 are represented by
Lordship,
comment departments.
There are only 4 respondents.
only for respondent.
Oh,
1, 2, and 3 is by the state council, and the 4 is the Lok Ayutta.
five is the
impugn order is at the page 99. Next R.
no, just a minute. Let me go to the course. Yes, there are only 4 respondents. All 3, order would be same. Item number 17, 18, 19.
Yes, Lordship, similar case.
Item number 17, 18, 19. Heard Mr. Foseco Forte, Learned Counsel for the petitioner. Also heard Mr. N. Angami, Learned Counsel for the respondent number 1, 2, and 3. Nobody appears for respondent number 4, that is Nagaland Lokayukta. It appears from record that by order dated 11/4/2023, the Nagaland Lokayukta was given an opportunity to engage new council, within a period of 3 weeks from the date of the said order. However, it also appears that instead of respondent number 4 in the said order, the Nagaland Lokayukta is mentioned as respondent number 5, and direction was accordingly issued to respondent number 5. In view of the apparent typographical error in the said order, the registry is directed to issue fresh notice to respondent number 4, that is Nagaland Lokayukta, to engage counsel to represent its case within a period of 3 weeks from date of this order. Let this case be listed again after a period of 3 weeks. In all 3 cases, same order.
For application, item number.
Let me verify.
I will take care, my lord. I will take care.
A common order may be passed, citing the case numbers of all 3 cases. Yes.
For admission, item number 24.
Please, Your Lordship. In this matter, I am challenging an FIR which has been registered against me, and this matter also can be taken up with the next item, 25. It's the same. Pertains to the FIR which I had moved this morning in the motion item. Earlier in the evening. The FIR, the Lordship may come to page.
No, your prayer is this. Item number 24 and 25 should be taken up together.
Yes, it can be taken up together.
The quashing of the same FIR.
Different FIR, part of the same transaction.
Okay, it relates to the items
which was moved in the earlier part.
In the same matter.
Same matter, but here
parties are different.
This is for the quashing of the FIR.
Earlier
was for the clubbing of these 2 FIRs.
Okay.
Yes.
Now you want to.
Yes, this was filed earlier on. Notice was issued. Notice has been accepted.
Okay.
And on the earlier occasion, the Honorable Court had passed an order to the effect that the interim prayer which was made in this petition, that is for consideration of the interim for stay of the investigation, would be considered today.
Now in this case, you will not be filing any reply.
Lordship, I filed one preliminary objection this morning.
Against the interim prayer?
Yes.
Lordship.
It has also dealt with the other paragraphs also. So more or less it's an objection to the petition.
So we can dispose it off.
Yes, it can be disposed. I am told that the case diary has also reached the London PP.
Case diary is there.
Yes.
Lordship, as the question might, today I've come only for the interim. And as far as interim is concerned, Lordship, this investigation is still going on. The petitioner is not cooperating with the investigation agency, so this investigation is still required, Lordship.
No, my query was whether today we can hear only as regards interim.
Subject to your lordship satisfaction, it can be disposed of because interim or no interim, my submissions should be same because I have to satisfy your lordship's mentions as to why interim should be granted. And while making such submissions, I'll be touching on the merits also.
If the respondents are not praying for submission, not praying for any further pleadings, no further pleadings would be filed from the side of respondent. Then if you are ready, otherwise ready, it can be heard. Or only on the question of
Except
interim.
on the aspect of investigation, Lordship, I have nothing much to say in other areas. Because it's a transaction between the petitioner and the perpetrators.
State is the prosecuting agencies.
But his prayer is only with regards to investigation, quashing of FIR.
Quashing of the FIR as an interim prayer, I've sought for still the investigation. But if the lordship is satisfied, then I can make my main submissions because interim submission.
Mr. Forte, you are ready.
Lordship, the affidavit that's filed in the juncture, I am only objecting to the interim. With the course of this matter, Lordship, I may be allowed to file a comprehensive affidavit, Lordship.
Has been dealt with. The other paragraphs have been dealt with in his reply objection. But with the rest, since your lordship will be dwelling only on the case records which are available with the CD as well as the FIRs, I don't think a reply or an objection or an affidavit will be necessary because it's only pertaining to 482 and your lordships very well knows the jurisdiction. So what should be entertained?
No. It is question of giving them, affording them the opportunity.
Yes, Lordship. I'm giving the opportunity, Lordship.
So, if they will be filing further pleadings.
Yes, Lordship.
Some objection petition.
Comprehensive affidavit to the criminal.
Then whether to proceed with.
Then in that case, I may be allowed to make submissions for the interim prayer, subject to your lordship's satisfaction.
We may fix a short date and hear it together because you are otherwise under protection of you got protection.
Yes.
So interim is not so urgent otherwise.
If it can be disposed of, if my learned friends agree, then if it can be disposed of next week, then yes, maybe we can.
Because interim does not appear to be so urgent in view of you are getting an anticipatory bail today.
Then can it be disposed of next week, subject to my learned friends filing affidavit at the right time?
There are some already prefix matters next to be difficult for all practical purpose. After maybe the following week or
after 2 weeks, Lordship.
After 2 weeks.
May I be allowed to make submissions if will your lordship be willing to consider the interim prayer? If I may be allowed to make submissions regarding that. I know the jurisdiction is very limited, but I may be allowed to persuade your lordship to come to a conclusion as to why this it's purely civil case, but a criminal color has been given.
Okay. No. It would be good if we consider the interim and the main case together.
Together?
giving a short date.
Okay. If a short date, then I'm agreeable to that.
He has suggested it.
Either 16 or 17. 17. 16 would be a EB day. 17, Lordship.
Is it okay?
May I suggest 14th? 14th of August.
14, Lordship. 14.
16 is a DB matter, 16 is a DB day, 17 I have a fixed matter, so.
You finalize.
Okay, 17 of this. But without any further adjournment on the part of the respondents.
Heard Mr. L. Iralu, learned counsel for the petitioner in both the cases. Separate orders will be there, but order would be similar. Heard Mr. L. Iralu, learned counsel for the petitioner. Also heard Mr. Foseco Forte, learned counsel for respondent number 2, as well as Mr. K.V. Angami, learned public prosecutor Nagaland. Learned counsel for the respondent number 2 has submitted that though he has filed objection against the interim prayer of the petitioner today itself, however, he prays for some more time to file a detailed opposition against the prayer of the present petitioner. You have any submission, Mr. Angami?
As versus the last occasions, order lordship CDs is arrived.
What we will do with CD, it will be retained or
Yes, I can read it.
learned counsel for the petitioner, learned public prosecutor submits that in pursuant to the order passed on 27/2023, case diary has arrived. On the other hand, learned counsel for the petitioner, Mr. L. Iralu, submits that he is ready to argue the case for its final disposal today itself, or otherwise, in case of any difficulty, he prays for hearing the matter of interim prayer made by the present petitioner. It is also submitted that in connection with the FIR, in connection with the case which was registered on the basis of the FIR which is sought to be quashed in the present petitioner, the present petitioner has already been granted protection of interim anticipatory bail in...
No anticipatory. I'm still in judicial custody.
Oh.
That was the co-accused.
Okay. Then this line, he is ready for... However, this court is of considered opinion that if this case if a shorter date may be fixed, then this case be disposed of. This case may be finally disposed of instead of hearing the interim prayer of the petitioner. Hence, let this case be fixed on 17th of August.
For final disposal.
For final disposal. Let the case diary be retained by the public prosecutor till next date.
I'm opposed. Same order for the next item.
Both.
We can just matter we take together.
Let this matter be listed again on 17th, along with the criminal petition number 11 of 2023.
Lordship, in the meantime, I will be allowed to file a comprehensive affidavit.
In the meanwhile, the respondent number 2 may file a comprehensive affidavit in opposition.
I will pledge.
For admission, item number 28.
Lordship, on the last occasion case study was called for.
Has it arrived?
Yes, I have instruction. Actually, in the first, the applicant was summoned under 161 CRPC. So, actually, not very necessary also to come before this court, but the Honorable Court was, this Honorable Court was gracious, generous, and granted at interim probation. And now, if she continues to cooperate with the investigation agency, there's no objection from the investigation, even if the bill is made soon.
Absolutely. She has appeared before.
Yes.
Mr. Siti Zamir.
No,
sorry. Heard Mr. I.
Im
Chen, learned counsel for the petitioner. Also heard Mr. K.V. Angami, learned public prosecutor, Nagaland. Mr. Learned public prosecutor has submitted that the petitioner had already appeared before the investigating officer and his or her. The petitioner is
her, she.
And her statement under section 161 has also 161 of the Code of Criminal Procedure has also been recorded by the investigating officer, and therefore the learned public prosecutor does not object to the making of interim anticipatory bail granted to the present petitioner by order dated 26/7/2023 absolute. I have also heard learned counsel for the petitioner. Considering the submissions made by learned counsel for both sides, the interim anticipatory bail granted to the present petitioner by order dated 27/6/2023 is hereby made absolute, with condition number 2 and 3 attached to the said order remaining intact. With above observation, this instant anticipatory bail application is disposed of.
Much obliged.
For hearing, item number 45.
His Lordship, this matter relates to prayer for granting of skill rate. Lordship, a petitioner was initially, just the fact of the case, Lordship. Petitioner was initially appointed as a laborer, Lordship, on fixed pay, Lordship, and thereafter, in that capacity, he has been working till date. That is, in September 9th, he'll be completing 33 years. Lordship, in 3 years' time, he will be retiring on completion of 35 years. Lordship, may kindly turn to annexure. Annexure 1, page 9. Lordship, since the petitioner's initial appointment order was displaced, Lordship, I have annexed the petitioner's identity card. Lordship.
Oh.
And there it is reflected his appointment order, Lordship, and the ending of
at
service.
page 9.
Page 9, annexure 1, Lordship. Lordship, petitioner was appointed in the year 1990, 2nd September 1990. So This September 2nd, he will be completing 33 years on fixed pay. And in 3 years' time, he will be retiring from the service. That is on completion of 35 years. Lordship, page 10 is a verification of work charge stuff. Here also the petitioner's appointment order, initial appointment, it is clearly reflected in page 11, Lordship. Petitioner name is serial number 33, Lordship. Lordship, and thereafter, on retirement of one Red for post, Lordship, on the same division, the petitioner submitted a representation before the authority for granting of skill waiver, Lordship, but till date,
Your representation is?
Lordship, representation is page 13, annexure 4, Lordship.
Yes.
Lordship, but till date, there's nothing has been done from the respondent side. Lordship, I have annexed, this court has been, on the similar issue, the court, Honorable Court has adjudicated the matter. Lordship, I have also annexed in my petition annexure 6, Lordship, page 15, whereby the Honorable Court has directed the state respondents to pay minimum of skill pay to the petitioners. Lordship, and on similar issue, the Honorable Division Bench upheld the single judge order by dismissing the state respondents' appeal. Lordship, I may be allowed to place this on report. Lordship, this is the recent order, judgment and order passed by this Honorable.
This you have annexed also?
Lordship, this one I have not annexed. After I filed this, only I have got this.
But this is there in the record.
Lordship.
Copy of?
No. I just collected just 2 months back after I have filed this.
Then somebody else have kept it.
Lordship.
It is there in record.
Oh, Lordship, maybe on last occasion
You
I
might have submitted.
Yes, Lordship. On last occasion I have submitted.
This you may take it back. Now,
Lordship, I pray that similar order may be passed, at least for granting of minimum scale of pay to the petitioner before he gets retired, because he will be retiring in 2 years' time.
now what was the order passed by single bench? For consideration of your petition, or direction was given to
Direction was given to the state respondents.
to give minimum of?
Lordship,
What is your case that?
Lordship, my prayer is to grant at least a minimum scale of pay to the petitioner before he gets retired, because it's been 33 years. He'll be completing
But
33
your prayer is that minimum scale of pay on the ground that similarly
Lordship,
situated.
similarly situated persons were also granted the scale of pay.
That
I will
you
tell
have,
the order.
yeah, no, that I have understood. But whether you have pleaded in your writ petition
Lordship, I have made.
You have shown with whom you are drawing up your parity.
Lordship.
With
Lordship, paragraph 5. Lordship, this.
you are a sweeper,
Lordship, no, laborer, Lordship.
laborer.
Lordship.
So what nature of work you do and with whom you are drawing your parity?
Lordship.
Yes, in
Lordship, I have annexed this. Paragraph 6 also, Lordship. Paragraph 6 and 7, Lordship.
6 and 7 you have mentioned.
Lordship, most respectfully submitted that petitioner had rendered his service with utmost sincerity and dedication for a very long period in the department, and in 3 years' time he will be retiring from the service on completion of 35 years. On so and so, and as such, he is entitled to enjoy minimum scale of pay. Lordship. Moreover, petitioner is entitled to the principle of equal pay for equal work like any other employee in the state government. Lordship.
You are reading at
Lordship.
Paragraph?
Paragraph 6, 7. Lordship, page 6 of my petition.
Yes.
And my prayer too, Lordship.
No, my query is with whom you are drawing your you are comparing yourself. That they are getting minimum scale, therefore I should.
Lordship, page 6, paragraph 5, Lordship.
Yes, there you have mentioned about
The incident case is a covered case, Lordship, wherein in great petition so and so, this honorable court, by order dated so and so, directed the respondent's authority to consider the case of the petitioner for granting the scale of pay, and further directed the direction.
Who were the petitioner before that case?
Lordship, I have annexed in my annexure 6. Annexure 6. This is a covered case, Lordship, where the petitioners, they are drawing, they have already been granted the scale of pay. Even prior to this, some petitioners on similar issue, they were granted a scale of pay. Lordship, I may be allowed to place this on record. This is this granting of scale of pay with the direction of this honorable court.
To whom?
The petitioners. Some petitioners.
In other cases.
In other cases.
What work they were performing?
Lordship, they were work touch employees.
Painter, helper, mason. Now, whether all work charge employees perform similar work?
Lordship, they are different. Some are mason, kalasi, different kind of work.
Yes, no, I am just trying to understand. The
nature of the work.
No, the principle of equal pay for equal work would be applicable
Lordship,
if
since
similarly placed employees are granted a higher salary, you can claim that salary.
Lordship, at
So
least a minimum scale of pay, Lordship.
Yes. So you have to show in your writ petition that person A, B, C were granted higher pay, they were similarly situated like me. Now you have stated that judicial relief has been granted to similarly placed employees.
Lordship.
On that basis, you are claiming relief in this case.
Lordship.
Then those petitioners of that case which you are stating that which covers your case
Lordship.
must be placed similarly to that of your in which the present petitioner is situated.
Lordship, they are all equally similarly situated employees, Lordship.
Okay, Mr. Imchen.
Though the state government, they are saying that there is no policy for granting of scale pay, but with the direction of this honorable court, lordship, many of my petitioners they were granted the scale of pay. But those only who comes to the court, they get relieved.
So, done.
Lordship, my humble prayer is that similar order may be passed so that at least petitioner may be allowed to grant the scale of pay before he gets retired. Because in 2 years' time, he will be retiring.
Yes, Mr. Imchen. A similar matter I have heard day before yesterday, where you were appearing, which is reserved. Is it a same case?
It is a
Similar case.
same as that.
What is your
My contention is that, Your Lordship, in absence of any specific policy of the state for granting a scale of pay to the petitioner or anybody,
You have submitted your opposition affidavit,
submitted my affidavit.
and the ground taken is that
Yes.
there is no.
Lordship, may kindly turn to page para 4 of my state counter. State counter.
You are also claiming minimum scale of pay on the basis of ROP of 2017, latest.
Lordship, whatever the said respondents they are giving, but as of which I have submitted placed before this, they are getting as per 2015, I believe.
Yes, Mr. Imchen, what is your submission?
My condition is in para 4, Your Lordship, of this state counter. I'm representing all the state respondents here, Your Lordship. May I read it, Your Lordship?
Yes.
That with regard to the statement made in paragraph 5, 6, and 7 of the writ petition, the deponent begs to say that there is no state common policy, common provisions, policy to grant minimum scale of pay to the dispatch employees. Furthermore, there are thousands of similarly situated work charge fee, tax fee employees in the department. As such, in the event of granting scale of pay to the petitioner, it will open floodgate or create precedents, which will create more problems rather than solving the issue. Furthermore, granting scale of pay involves huge financial implication, and as such, in absence of a clear policy adopted by the state government for consideration of the workers' skill pay, the department is not in a position to consider the case of the petitioner, even though they have served the department for a long period of time. Next paragraph. Furthermore, the deponent is sympathetic towards not only with the petitioner, but also towards many of his similarly situated employees who claim that they are the sole breadwinner of the family and finding difficulty in maintaining the family with Medicare pay. However, the above reason is not a criterion for claiming scale of pay, for the fact that there is no provisions in granting scale of pay for appointment on contingency basis at fixed fee, and that too terminable without any prior notice.
So yours,
Your Lordship, as usual, my submission before Your Lordship is that, Your Lordship, the state has not formed any policy, framed any policy. So, in absence of a clear-cut policy framed by the state that relates to the grant of skill of pay to the work charge fixed employees.
Okay.
Lordship, this is the clear proof. They are saying that there is no policy, but many of the work charge employees who are junior most to the petitioner, they were granted scale of pay, Lordship. But only those who approach the honorable court.
Okay, heard. This was item number 45. Heard Miss Asangla Waling.
S. Longkumar, Lordship.
Sorry.
S. Longkumar.
Heard Miss S. Longkumar, learned counsel for the petitioner. Also heard Mr. Moa Im Chen, learned senior government advocate.
For all the six.
For all the state respondents. I am reserving it. Hearing concluded, judgment reserved.
Okay.
Good finish.
Two items, but analogous, yes. Office another. Sao bảo mình sẽ tiếp với ông cái fight để